Hi, everyone. If you could please be seated, we'll start now. Thank you all for coming over for PrivacyNama. This is the third edition of PrivacyNama. And we started this conference in 2020 with a very straightforward objective, saying that there are conversations that are happening that are focused on one minor aspect or the other. And then there are global conversations happening on privacy. So can we zoom out and take a look at the themes that are determining where privacy is going globally? So this year is a little different because there are many more Indian speakers involved because we have a law. But broadly, our approach has always been that can we build a conference that becomes a hub in South and Southeast Asia for having conversations on the future of privacy. We have a data protection bill in India now, but we don't know quite how to implement it. I think there are 27 aspects for which there are rules that have to be framed. And then there are rules that can be framed for aspects that are not even considered in the bill. We don't have a data protection board yet, but I'm sure eventually we do. But we know that it doesn't have half the functions that it should. And so the ministry is largely going to regulate and build rules for the industry, for startups, and also for what impacts user rights from here on. And so for us, it's important to understand what are the rules that need to be made, how should those rules be made, what is the framework for even the process of making those rules, what are the areas where those rules are needed, where is there confusion, where is there clarity. And the purpose of PrivacyNama this year is to shed light on all of these things. What do we know from the bill? What do we not know? And what do we need to find out? And what are the principles of implementation of privacy that we need to have in this country? And hopefully, through this conversation, can we define principles that the government is going to basically, or we can show to the government saying, this is the right way of building out the implementation of the privacy law in this country. What should businesses be prepared for? There is, again, a lack of clarity. Verification is one area where there is absolutely no clarity on how that's going to be implemented. Frankly, what we have in terms of a requirement of verification for children shouldn't be in the rules in the first place. It's impossible to verify in an informed manner only children, unless you're doing Aadhaar authentication for everyone. We have, for this conference, we'd like to thank Salesforce, Google, PhonePe, and Meta for their support, and CCG and CUT, who are partners for this discussion. Today's sessions, and this is a 2-day conference, today's sessions are going to be on notice, consent, and processing of data, on children's privacy. And lastly, we'll have a Chief Privacy Officers Conference, where we'll discuss what are privacy officers thinking about what needs to be implemented and how they need to go about things, about implementing the data protection law within their companies. And I think for me, that is one of the two most important sessions of the discussion, because it's when the rubber hits the road that you really understand how difficult it is to implement a privacy regulation, and it's their job to make it happen. Tomorrow, we're going to have a session we're going to begin with a session on user rights and how they've been impacted and whether anything's been salvaged from this bill. We're going to talk about, there's going to be a data protection commissioners roundtable. We're going to talk about cross-border data flows, obligation the data fiduciaries, and finally, on the role of the data protection board and what sort of an approach it should take to adjudication mechanisms, etc. So tomorrow's a longer day. Today is a relatively shorter one. But thank you all for coming in today. I'm going to hand it over to Aarti. Aarti and Saraswati have mostly put this conference together, and they know much more about these subjects than I do. I'll hand it over to Aarti. Thanks.
Thanks for that, Nikhil. And up first today, we have a session on notice, consent, and grounds for data processing. This is really the cornerstone of the bill upon which all these activities that companies using technology are kind of going to be impacted by. So without further ado, I'd like to invite the panel to the stage. Moderating today's session, we have Srinidhi Srinivasan from Ikigai Law. And participating in person, we have Richa Mukherjee from PayU. And we also have Rajiv Sharma from Tata 1MG. Tuning in online, we have BG Mahesh from Sehmati, and we also have Abha Tiwari from Renault. So thank you so much, everyone, for joining us, and look forward to hearing from the panel.
Hi, hello everyone. It's lovely to be here. Thank you so much, Aarti, Nikhil, and the MediaNama team. Excited to kick off this year's PrivacyNama. It's all the more exciting because we actually have a data protection law in place. The law is, of course, in place. We're waiting for some rules to offer some clarity, but the structure is in place. So we'll be talking about really operationalizing the law. What are practical challenges? What does the law look like in practice on user interface, on an app, in documents, in agreements? What does it look like for different sectors? And we'll really delve into the notice consent piece today. Do we have Abha and Mahesh on the screen? Okay, great. So I'll probably just turn to them whenever I want them to come in. I have a great panel with me today. Richa, Rajiv, Abha, and Mahesh, who are tuning in from elsewhere. So this session that we're sort of kicking things off, like Aarti said, notice consent really is the cornerstone of this data protection law, which is premised really on how individuals are going to be able to control information that's about them that organizations are collecting and using. And the way to do that is to be transparent through a notice and hand users control through the consent framing. It is, of course, a critical piece of the law, essentially because any data that you're collecting has to be justified either on the basis of this notice and consent construct or under one of the 9 legitimate uses that are recognized in the law, and including the very intriguing provision around deemed consent, which also we'll delve into. So I think I'll jump right in we'll sort of structure this in a way that we can touch upon the notice consent piece and some conversation around the deemed consent requirement as well, and then talk about consent managers, particularly also bring in Mahesh on his experience with the account aggregator framework on that aspect. So maybe Rajiv, I'll come to you first. Just on your thoughts on the notice requirement in the law. The law, of course, just says that whenever you're making a request to an individual for their consent, you must give them a notice. The consent has to have these three things to make sure that users are informed about the data, the purpose, what are individual rights, how can they complain to the board. So just to kick things off, maybe if you could offer your thoughts on, is this sort of enough? Is this notice framing enough? What does the notice actually mean also? Is it a privacy policy? Is it something else on the UI? So I'd like to maybe invite you to talk about that.
Sure. No, thank you. Thanks for having me here. And that's probably the most important part of the entire DPDP Act. And when it comes to notice, notice effectively asks you or asks of you to ensure that the person whose data it is understands what the data will be used for, what purpose for the data will be used for, as well as for how long data will be used for, as well as in terms of what are the risks associated with the data being used, whether internally by a fiduciary or a platform, or even outside externally, because the data boundaries are pretty much fading these days across platforms and within one platform. Now, is it enough? Not really, because just having a tick in the box for privacy policies on terms and conditions, it is not the right approach to assume that the owner of the data understands what will be the purpose of the data, how it will be processed, whether he has any right or reservation for that data usage. So it's very important to ensure, especially when it comes to big platforms and data platforms, as well as marketplaces and companies, to ensure that they take an extra step or make efforts to ensure that the user understands what the data will be used for how long, and what will be the purpose of the data usage. So it's pretty much important. Now, it's easy to say it, but when it comes to businesses, you would not want Amazons or Flipkarts and all the rest of the big platforms to keep sending you pop-ups every now and then to tick in the box that, okay, you can use my data for this or that. So there has to be a very delicate balance between data accessibility, transparency that is supposed to be given to the user for enabling him to make a choice, as well as the risk associated with it. So there needs to be very transparent messaging made to the user for that to be done. And that's something that we are not right now very clear upon. But I would say, with just the premise of notice, I would really want companies to go one step ahead. And there are a few examples in EU GDPR and a few other places where we can look up to for transparency and accessibility and affirmative tick in the box. And that's how it'll be. For the second point that you spoke of, which is how will the privacy policies get impacted? That's an important one, because right now it's a tick in the box and everything is written in fine print there, and nobody really goes through those scores of pages of information that is asking or taking permission or indemnifying. The second point, the data usage. Now, for a high frequency platform or high frequency data usage by a platform where people interact a lot of time, it will have to be designed very meticulously versus a low frequency platform where it will be designed. Because if you're using a platform and every time you are making an order or making a return, or you are choosing from different sets of televisions, or it is easier to keep it in the side and not have too many ticks in the box. But when it comes to some platforms, let's say, for example, you get your health report for your full body health checkup, that is probably once in a year. There it is easier, when I say high frequency usage when it comes to data. So from a privacy policy designing or terms and conditions that we would need to work upon, it'll have to be quite a bit of innovation in terms of designing it in a way that notice balances transparency as well as user experience, to say.
Great. Yeah, I think one thing we often talk about is so far a lot of the privacy conversation has been centered around like lawyers are telling you stuff, everything in the privacy policy. There's a whole bunch, the agreements, contracts, but here there's room for the product folks, the business folks also to really come in and help shape what meaningful notices and consent, be through a checkbox, through a hovering pop-up that comes up, what are the right times in which these come up, all those sort of become interesting questions there. And I was wondering if I could bring Abha in here on just this balance that Rajiv also spoke about. We don't want to be bombarding users with too much information. I don't think that's the intent of the law either. But how do we sort of find that balance between conveying enough information, keeping the UI clean, or whatever communication you're displaying to users clean, but still making sure enough information has been passed on to individuals? Particularly interested to know if there are any learnings from global privacy laws, including the GDPR, for this.
Thank you so much. Great to connect with you. I hope someday we are able to meet in person.
Just a moment, Abha. I think we can't hear you.
Can you hear me?
Yeah, can hear you now. Please go ahead.
Thank you. Thank you so much. I hope to see you in person soon someday. So coming back on the question, and as Rajiv has pointed out, there's this host of information that is required to be delivered to the customer, because the idea is accountability and transparency. It is to empower the user to make an informed decision. And then it also corresponds to a regulation, because if you don't comply to that, then there are going to be penalties. Let's go back to the days of FIPs, the Fair Information Practices. If you look at it, there is a universality into the information which is required to be provided to the data principal or data subject before the data gets collected, which basically is, who are you as the data fiduciary? What are your contact details? What information are you collecting? How are you going to process this data? And so on and so forth. And this also happens to be a living document. So when we try and take examples from any other jurisdiction, and I would try to bring in how US addressed it or how GDPR addressed this, there's a convergence somewhere, because everybody, we've seen that right after GDPR came in, we saw a lot of lawsuits that were filed against various organizations, and the whole thing was that the privacy notice which is being delivered it is either too complicated, has too much of information, it is not legible, it is not readable, there's a lot of bundling which is done, so on and so forth. A statistical point here is that there was a study which was conducted for how the privacy notices were delivered between 1996 to 2021. 50,000 privacy notices were studied, and it was found that if we just take up the basic privacy notices of the websites or of the places that we visit in our regular day-to-day lives, it needs about 400 hours to read all of them. 400 hours also means it is more than 1 hour per day. So that is the enormity of the information that is required to be delivered. Coming back to DPDP. Now, DPDP also details that there are certain essentials, such as purpose of collection, manner in which the data subjects can exercise their rights, the language, the multiplicity of languages in which it has to be delivered, and and various others, the contact details of data fiduciary, who are the data fiduciaries or data processors with whom that information is likely to be shared. So again, the information load is huge, but it has to be delivered. And how should this be delivered to the data subject? I will go back and take certain instances that are universally recognized again, and this is something which is followed after GDPR. Of course, it gained a lot of relevance. Few rules that must be kept in mind. Rule 1, please try and understand who's the audience to which this privacy notice is required to be delivered. How the user is going to review it, which means what is going to be the screen size. Is it going to be something as big as the laptop or a desktop, or is it something which is as small as, say, a wearable device? Who are the users? The primary users and the secondary users. When I say secondary users, in, let's say, smart homes or in a car, you not only have, so the data is not only captured of the one who's driving it or the one who's, or where the ownership lies, but the passengers as well. So data gets collected and personal data gets collected. So voice samples gets collected, etc. So that also that gets processed. Like we said, The idea is to help the recipients make an informed decision. So there are 5 ways of doing it, 5 ways how they can be delivered. One, layered notice. So layered notice essentially is a flow down. And again, these are universally recognized, considered best practices. So layered down, which means that just the right amount of information is provided to the data subjects, and then there are links. So if the data subject is interested, they can click that link and go on to another page and so on and so forth. But it should not be more than 3, a flow down term should not be more than 3 layers of notice. Second is just-in-time notices. So just-in-time notices so these are preferred modes of delivering the notices in those circumstances where there is a life cycle, which means that at different stages, the data gets collected. So right before the data is being collected of the data subject, there is a notice which is delivered to the data subjects. Third is the icons and symbols. Now, icons and symbols have also got a reference in GDPR. I mean, we do not have it in DPDP, but in GDPR, they have a reference. And now these icons and symbols don't exist, but it's like the danger sign that we see. We all know that this is danger sign, and this is what it means. So likewise, if there could be certain signs, certain icons, certain symbols that can be delivered, or that can be, we can, formulate something and they can be used and they could connotate a meaning, but then it's like my symbol is as good as your symbol. So it is to be the same symbol so that it is readable. It could be, it's relatable. Then QR codes. So QR codes, preferred mode again on smaller devices or wearable devices where you can just scan it, where the user can scan it and see, read through the privacy notice and be informed about what data is being collected and all of that, considering the screen size. And lastly, on the privacy dashboard. So privacy dashboard would be that one place where the data that is collected, processed, details of the data fiduciaries, and all the elements that are required could be stored. While I share these 5 methods, considering the experience that we have after GDPR or with CCPA or privacy laws across jurisdictions, we've also come across certain instances where the privacy notice is delivered in a format which is both audio visual. So it'll be a small clip which is playing. And why it is important is that when we are as organizations required to deliver a notice, this is not only to the data. So, our customers, for example, this notice will have to be required to be delivered to whole spectrum of data principals. Could be your vendors, could be your applicants who have applied for a job, or could be any third party where the personal data gets collected and processed. The more meaningful it is, the more engaging it is, the better it is, curated and drafted, the more it will help the data subject or the data principal make an informed decision. And it will serve the twofold purpose. That is, one, be compliant, and 2, ensure that the data subject is aware of their rights. And it is, in that sense, the empowerment. In that sense, the data subject would be in a position to make that informed decision.
Great, thanks, Abha. That's super helpful on just the piece that there's, of course, your long form privacy policy, which is describing everything that you're doing with the data. But how do you break this down and communicate this on the UI? And in that vein, perhaps if I could bring in Mahesh here, just maybe to, from your experience with the account aggregator framework and the consent artifact there, any learnings and any sort of thoughts also on what Abha also mentioned about the different kinds of notices. If I could bring you in, Mahesh, there.
Sure. Thank you for calling. I mean, so I wish I was actually there in person. It makes it more easy. Okay, so to actually give you all the context of where the account aggregator ecosystem is there now, I think that will also help you in everything I speak about AA. So we have like about 17 account aggregators today, of which 13 of them are having what we call the operating licenses. Account aggregators are actually consent managers for the financial data. Any entity which is registered and regulated under any one of the 4 financial service regulators, and now which is expanded even to the taxation, which is GST, are able to participate in this ecosystem without any extra approvals which are required. So as of today, every day the number of consents which are successfully delivered is about 1.6 lakh consents are delivered every day, and about until March 2023, about $1 billion of loans were given out, which were powered by the account aggregator framework. So the learnings I would say is, I think we started off well with 5 purpose codes, which is somewhat generalized, and I think we can speak later. We think we need a lot more focus and linked to particular use cases. We need actually the purpose code. So the learnings we have had, as also we actually heard from actually a panelist, I think, was about the consent. The parameters shown should be an explicit consent, and the mighty consent framework very clearly says what fields have to be there. The purpose code, who the FIU is, the entity which is going to use your data, for what period of time it can use the data, which is the data life. But who knows that what is the right values? Actually, we don't know that. Okay, about the frequency, say, for example, if it is a personal finance management app, is it okay for a PFM app to request for the data, once a day, or 50 times a day, or 100 times a day? Now, if you're applying for a personal loan, is it okay for the lender to ask for 1 month of your statement, or 6 months, or 1 year? So what we have done at Sahamati is, we have come up with a library of the consent templates, that for so-and-so use case, the parameters value should actually be this. And we have ensured that, about the layering down what she explained, that these parameters in the very opening screen of the consent framework have to be clearly shown to the end user. And as we go forward, we have also seen many users have asked that the your consent framework, the artifact should not be in one language. The user should have a choice in which language it has to be shown. So, to summarize that, I think it becomes important that the important parameters are shown. The account aggregator, I'm hoping we can warn the user if the value of any of those parameters are outside the usual range is something which the account aggregators are yet to start doing, because the ordinary user, or I would say even the informed user and the so-called the very well educated user, has no clue on what the right values are.
Sure. And like you said, I think those consent templates sort of help templatize this for different sectors. But just maybe a follow-up or two there before I come to you, Richa. Consent, the account aggregator is, of course, for a very, very specific use case. There are FIUs and there are FIPs, and it is to enable that sort of data sharing.
Correct.
Just on how do we kind of, operationalize this at scale beyond the financial sector? And also, who makes that decision on how many parameters are necessary? What is the data that you're collecting, whether that's sufficient or not, the frequency of notice? I think a lot of that has to be left to the businesses, right? Or to each individual sectors also to evolve and develop. And I'm just wondering if the rules can help offer some clarity there. Mahesh, if you had any thoughts on that.
Sure. See, according to me, the rules will not go so deep upon the use case and the mapping and all of that, and it should not. For example, Sahamati is is actually an entity which is working with this entire ecosystem, and all the rules and the good practices which are actually coming up is not from us, but from the ecosystem. We only orchestrate we facilitate and we actually speak with the ecosystem and agree upon your good behavior. Of course, okay, then comes what happens if you have the bad boys. Okay, okay, then who will take the actual action? Somebody cannot take action because we are not regulated or actually blessed or anything like that. So it is the regulator which will ultimately, which will have to take, the action. Scale wise, I think it has started off well. Like more than 20-25 million users are already using. Almost 2 billion accounts are already on AA, but we still have a very long way to go.
Sure. And just maybe a couple of follow-ups there as well, but I'll come back to both Rajiv and Abha, but I wanted to bring Richa in as well. Richa, of course, you operate in a slightly different place where a lot of your customers are actually entities, merchants. You don't directly interact with end consumers, or maybe you're not using their data in your own right. So just wondering what your thoughts would be on the notice consent framing, and what does this mean for processors, data, at least entities that are predominantly processors?
Right. Good afternoon, everyone. And thank you, MediaNama, for having me here. Glad to be here. So I've been hearing about consent and notice. So if I have to start, the entire premise of DPDP 2023 is to safeguard the customer data. And then we have the data fiduciaries, which protect the customer data. They seek consent, they give prior notice. They help in the retention of data, storage of data, etc., etc. But for us, we are a payment aggregator which sit very cozily between the merchant and the bank. Most of the time we are hidden from behind. We work behind the bank, but we are an integral part of the ecosystem. Now, when we are talking about the consent and the notice, the data that is when a customer is making a payment, when is making a purchase on a website, online purchase, the data that is transferred to us via merchant, it is in an indirect way. It is not via direct, because we do not have any interface with the end consumers who is making the purchase on the website or any online platform. So the entire premise that we are not able to have the direct interface with the customer. So how do we give the prior notice, or how do we seek the consent, is a bit challenging, especially for the entities and the intermediaries like us who are operating in the B2B space. What I feel is, for the intermediaries like us, there should be either a special carve-out wherein we are either given an exemption, or there should be a facility that the notice or the consent can be given at a later stage once the processing is done, with a clear opt-out facility.
Sure. And also, I think this speaks to the question of what your role is. Often you're only processing, you're only a data processor on behalf of the merchant. So I was also wondering if we could expect to see a lot of changes in those merchant agreements, where your ability to have that data vests entirely in the merchant agreement. So do we expect changes there?
So I would say to that is, yes, definitely there would be changes in the contractual agreement between us and the merchants. Apart from that, I would also see that there should be a provision of kind of a master consent or an umbrella consent, wherein if one data fiduciary or whosoever has a direct interface with the consumer, they are taking a consent, that should be the overriding consent for all the other data fiduciary in that ecosystem. Of course, with a fixed set of purpose, because we have to define the purpose. If the purpose is same, then there should be provision of some kind of a master consent that should ride on this. Otherwise, it'll be difficult for entities and intermediaries like us.
Sure. And maybe then if I could also bring in each of you to talk about on the notice piece, what sort of clarity could we hope for on from the rules? Rajiv, if you could. Specifically, would be interested to know, in the health tech space, is there anything specific to the sector that we could benefit from in the rules, or either through industry-led efforts as well?
Yeah, sure. I think that's an important one, because if we get some sort of guidance wherein we could actually look at the 3 or 4 pillars that we spoke of, which is data type, how we want to process it, who will process it, and for how long. I think if there is clarity on that, and if I have to take an example, when it comes to health tech, let's say patients have a lot of data when they go to a hospital, and a lot of data is generated, and these are stored in electronic medical record systems, and it has your chief complaint, it has your history of chief complaint, it has your family history, your past history, and it also has your prescription. At the same time, it has very, very sensitive information of how old are you, what's your name, even to a certain extent your credit card information. Now, there are so many different types of data types in this one data set that if a patient wants to share this data with someone, even inside the hospital ecosystem, whether it be a doctor, whether it be a nurse, whether it be a physiotherapist, whether it be an accountant at the reception, it's very different data sharing that is required for each of the actors. And for how long also totally depends on the kind of actor there is. And if there is some sort of clarity on that in terms of, okay, for a particular category or a set of data, this is the type of data that can be shared. This is the type of data that a user can decide to share or not share, and there are enough means for him to do it. I think that will really help. Now, the point here is that the example that I've taken is for a very low frequency throughput industry where a person would probably go to an OPD maybe 2 or 3 times a year, or he would go to an IPD maybe once in 2-3 years, or maybe once in 5 years. So I think there could be still some sort of definitions for different types of data usage for different types of actors, wherein when it comes to rest of the other e-commerce sites and platforms where there are multiple types of different buying behavior of the consumer, I think a clarity on what kind of data can be shared for how long, for what purpose is very, very important. Not just from the immediate use case of data when it comes to buying or selling, or sharing data and sharing your address and for all the Swiggies and Flipkarts, but at the same time, if for how long would you want to share that data, and if at all, I think Abha mentioned about the board. If the person wants to even retrieve the permission of using that particular type of data for the use case. So I think that's how I would see if there is more clarity in the rules in terms of some sectoral guidelines, hopefully, or at least with some examples which can be aped and replicated by industries. That will be really, really helpful.
Got it. I'll push back a little though there, because just there may be so many myriad purposes, like you said, exactly, right? Like different kinds of use cases. It might not be possible to quantify also those timelines, but the principles that you mentioned, low frequency, high frequency, maybe that can offer some sort of a template, at least even for businesses to identify how long might data be needed for some purpose.
Definitely. I think if we can categorize into a couple of categories like low frequency, high, or maybe mid frequency, and even if some sort of sectoral demarcation can be done to guide those industries, that will be helpful. Again, going back to the first question that you asked on the notice types and additions to the notices, I really strongly feel that I don't think rules can capture all of this. And I think you're pointing out on the same thing. But some sort of guidance will enable the industry to come out with the right set of rules, with the right set of industry practices around notices and consents. And that will generally help the user as a whole to develop the kind of trust, giving them the kind of transparency that they need, for which the entire DPDP Act is getting formulated. So super important.
Sure. I am mindful of the time, and I do know we want to talk about consent and deemed consent as well. And so, Abha, maybe if I could come to you, we've talked about notice, and we'll talk a little bit more about consent as well. But there are 2 ways in which we can legitimize data processing. One is the notice consent framing, and the second is if processing falls within one of those 9 enumerated legitimate uses. one of which is a deemed consent sort of provision, which says if you given somebody your data voluntarily and not objected to its processing, then that's also fine. I was just wondering if you had thoughts on that and how this might contrast with the legitimate interest ground basis that we've seen in GDPR and other data protection laws around the world.
Thank you so much for that question. And that's indeed one of the questions that we have been trying to understand and break it down from a perspective of how is it different from GDPR, where has this been taken from, etc. What I could figure out so far is that the concept of deemed consent was first brought in the bill of 2022, unless I'm mistaken. We also see that a lot of time deemed consent finds a reference in law, which is whether silence can be construed as an affirmation. Can it be seen as consent? But we also have cases where it says, no, silence cannot be construed to be an affirmation. It cannot be construed to be consent. The question is, what would deemed consent or legitimate use, as it comes in 7A of the DPDP Act, will mean? We have globally, we have two jurisdictions, Singapore and Australia. Singapore has something called deemed consent. Australia has something called implied consent. In both these, and I'm trying to draw an analogy to say there's something which says that if the data is provided voluntarily and the intent to withdraw the consent has not been communicated, which means the consent is not revoked, the data can be processed. But if we are to take it against, and these are the places where the data subject technically has the right to withdraw consent or opt out of it. However, the data subject has chosen not to opt out of it. Let's go to GDPR, where we talk about legitimate interest. Now, legitimate interest is a far wider ground for processing data as compared to legitimate use. One, legitimate use is restricted to the points that are mentioned in the Act, to 7, 8, 9 points that are mentioned in the Act. Legitimate interest, on the other hand, says that organizations can process data provided they are able to have some sort of proportionality. They do a legitimate interest impact assessment, where they sort of balance out between the interest of the organization, the commercial interest, economical interest, etc., versus the fundamental rights and freedoms of the data subject who could be impacted by that. Now, this is not equal to legitimate use or deemed consent, as we're talking about, is absolutely different from legitimate interest, which is given in GDPR. How or what could be the playground that we might get under DPDP? It is going to be very restrictive. If we look at the illustrations that are given in the DPDP Act itself, and my first thought on that is that the usage of the data, or if any organization chooses to process this data on basis of legitimate use, there has to be an inextricable link between the primary purpose and the secondary purpose, which is clear. Unless, of course, the rules come out and say that no, there could be some differences and this could be construed as legitimate use, etc. That happens. This also means that a lot of ground that we had under GDPR, when we talk about legitimate interest, such as opt-in. So soft opt-in was a concept where if you have sold a product to a customer, we all know that the customer would be interested in knowing what new products will I be launching, what services will I be providing, what sort of offers that probably will come in future. So here in certain jurisdictions in Europe, we were able to send these communications to the customers. But as I see it today, that may not happen. Like there it used to happen, provided there's a possibility of opting out. Here it will not happen, because here it gets very narrow and it gets very restricted and it has to be narrowly interpreted.
Sure. Yeah. Actually, if I could ask you to also maybe share some examples. Completely with you that this is a completely different paradigm from legitimate interest. Here, this is it's about voluntarily providing data. Legitimate interest is a wider legal basis or ground for processing. But just given the paradigm that we're in with consent and the current legitimate use we have, what might be examples of these secondary purposes that you're mentioning, right? Like primary and secondary purpose, and where could those potentially fit in within the law?
So I'll give you an example from the automotive industry itself. So let's say we sell cars and we are surely interested in letting the customer know of the offers that we will roll out, referring the car that the customer has bought versus the new product that can come in future. So if I talk about legitimate interest, I surely have as an organization, I surely have the interest of retaining the customer for a longer duration. I would want the customer to be there with me lifetime. And so it is in my interest, and it is also in the interest of the customer that I'm able to offer them all the products, future products, lineups, call them for conferences, etc. Help them, make them participate, call them up for their warranty services, call them up for if there is a new insurance, something coming up. So I have a legitimate interest, and the customer also will be benefited out of it. So let's say today I draft a notice where I say that while I'm selling you the car, I'm going to process your data for so and so purpose. If you are interested in, say, marketing communication, so now I have to split it in two: marketing communication with reference to your vehicle versus marketing communication with reference to all our product, future products, etc. The customer chooses not to mark the second option, future products, etc. So there is a loss that will happen to me. I cannot club it as a primary and a secondary purpose, because it is the prerogative of the customer to choose whether he would want to be with me or he would choose another automotive. That is the prerogative of the customer, and I surely cannot link these two. Earlier I could have, now I cannot. But let's say if I have to call the customer for warranty services, or let's say to make sure that the maintenance schedule of the customer is taken care of, or I have some offers that I can provide to the customer, that is an interest to the customer. But if the customer chooses to opt out, because again it is voluntary processing, and again where the customer has not opted out, I have to give him the option of opting out, and if he opts out, then there is a loss that will occur to me as an organization as well as the customer.
That's helpful. Essentially, we're identifying the core purpose, and whatever is almost incidental to that purpose, we view that in one way. But anything which is completely distinct, a new product, new offering, distinct, or we view that sort of separately. And I'm wondering, Richa, what that might mean for fintechs then. For a lot of fintech payments businesses particularly, often payments itself is like a customer acquisition cost, that you acquire this data and you cross-sell a more lucrative product to the end user. What would the law then mean for these type of practices?
That's why I will answer this with an illustration. So suppose there is a consumer who wants to avail the buy now, pay later facility from a fintech company. So that fintech company, whether to assess its credit worthiness, it has to do certain checks like user profiling, behavioral analysis, risk analysis on that customer. Now, how does it do that? It has to take the data from various other entities, from third-party entities and various other sources. But how do they take the data to assess the credit worthiness from those different entities, A, B, C, D, howsoever many they are? So there has to be a mechanism wherein the data sharing between these third parties is made available to that fintech company who has to provide for that facility. So in all of this, there has to be right amount of consent and notice. But again, in the B2B space, that is kind of a challenge. So that kind of a framework has to be made provision for in the fintech space.
Sure. Perhaps then that gets addressed in the agreement. And also, I think we were talking about different sort of pop-ups coming in. But yeah, with the B2B framing, you're one step removed from the end. Sure. And Mahesh, if I could bring you in as well, I know you talked about purpose codes earlier, and because we're talking about core and incidental purposes, how is sort of purpose defined in the consent artifact? And also, I think one piece you talked about earlier was while we define all of this, and there may be market practice also that develops, is there a way to actually ensure that the organization is using data only for that sort of purpose, that the purpose specification seems to be geared towards that objective?
Yeah, firstly, in the account aggregator ecosystem, Rabbit has already defined 5 purpose, actually codes. Like it is, to give an example, collection of the information for wealth management, for the purpose of your loan processing, etc. But it is The way I feel is it has to expand a lot more, because now what has happened is the number of entities which are participating in this ecosystem is close to 400. So now as more and more entities have come and we have heard from them, okay, that it needs to get more specific, because now only when it gets more specific, it actually flows down to what you asked. How do we ensure about how the data was used? So here comes the data governance. So here the FIUs at this, some point of time should be able to demonstrate that the way it was used, it actually matches with what they had declared. Say, for example, they have collected the data for the purpose of loan application processing, then they should be able to show that it was used only for loan, and that entity has not passed on the data to their, say, for example, wealth management division, the insurance division, etc. So now, Samati, like as we speak, for the past 1 month, we are working with a lot of entities to come up with a framework on how this can be demonstrated. So one topic which you all might have heard of is confidential computing rooms, where the FIU will have the data there, and only the authorized departments will be able to actually go in and use the data, and nobody else is able to go in. So if anybody is accessing that information, obviously it will have a digital trail, but it is not an easy problem to solve. Okay, because for the amount of digital data now which will now flow in this ecosystem, in view of the AA framework, as I told you, now you have about 400 entities, but the number of entities which qualify to participate in this ecosystem is 10,000. So you can just imagine, when all these entities are on this, how many questions everybody will have. Is my data safe? Is it being sold? Is it being used for XYZ? So I think it has to be solved using technology tools only, because that's the only way it is scalable.
I had a question,
Sure.
and this is purely from and not just for Mahesh, but for all of you. How do you think we can codify rules for enabling deprecating consent? So, for example, what we see is that when you, let's say, install an app on Android, there are instances where there are permissions that are taken, but if you stop using it, it automatically removes permissions for those apps, right? I'm just curious about how that, I mean, that's one of probably the most important privacy protecting frameworks that I've come across, because it allows, you shouldn't be giving consent for life. So A, what impact does it have on businesses with deprecating consent? B, do you think that that needs to be one of the considerations? And if it is, then in rulemaking, how do you build in deprecating consent?
Yeah, so in the account aggregator framework, you have your two types of consent. One is a one-time data fetch or one-time consent, and one more is a recurring consent. So in the case of a recurring consent,
no, Mahesh, the other thing, one is recurring consent, but
Yes.
the other is diminishing or deprecating consent. Let's see, reverse.
You want to stop it?
I want to stop it, or I want there to be a framework where consent once given can actually, it can actually stop after a period of time if a user wishes that to happen.
No, okay.
Otherwise, the problem is once that data pipe opens, it remains open forever.
Yeah,
And
so in a recurring consent, Nikhil, you are able to revoke the consent at any point of time. At any point of time. But the question comes, as you asked, or even as she asked before, how do you ensure that the data which was collected in the past is also not yet being used. Okay, so it is something which the FIU or that entity has to demonstrate, and one has to understand all the entities which are participating in the AA framework are regulated entities. Okay, so they have an obligation even to demonstrate to their respective regulator, okay, that what they are doing is according to the rules. So to summarize, that you already have in the framework a way to revoke and a recurring consent. It's already there.
And I think, Nikhil, you're talking about data retention as to whether we continue. Are you talking about data retention in a way that once the purpose is met, you actually don't need that permission anymore?
Again, so in some instances, determining whether the purpose has been met is not clear, right? So, I mean, the Android example is great because what happens is that, let's say, if I have an app, let's say I have the Flipkart app, and I stop using it after a period, let's say for 4 months, I haven't used that app. Android automatically revokes permissions.
Okay.
And if I have to use it again, I need to give permission again. So it builds in a preventive framework. Just because the data pipe is open, they shouldn't be able to continuously collect data from the device, because all apps don't just collect data from using the app. They collect, for example, phone status. They collect sometimes location information. They collect, they skim SMS information. We've seen all of that happen over the years. How do you create a framework for protecting user rights and how does it impact businesses if consent gets deprecated?
Sure. Richard, do you want to come in? And maybe I think Abha also raised her hand.
I want to make one statement. I think what you're saying, deprecating consent, somehow it should also be covered in the rules, because it should be ideally be in the purpose. It says what is the purpose of taking a consent. So if you define the purpose, say for data processing, so till the time the data is being processed, the consent will be valid. And once that stops the purpose, it will automatically deprecate or get over. I mean, that's what I understand.
Correct. But let's say if I stop using, if I'm continuing to use a Flipkart app, it remains. But if I haven't used it for 4 months or 3 months, the permission gets revoked. That way, I'm just saying that
essentially the app is it's dormant. That relationship is
unused. There is no engagement between the consumer and the business that has collected the data.
Allude to that, right? In the retention timelines, where it says that the government may come up with timelines for when the purpose for collection is deemed to sort of have been met.
Payments. So retention is different because retention may be necessary for legal purposes.
Sure.
But continuing to collect data is a different game altogether.
Sure. Abha, did you also have a thought there? I saw you raised your hand.
Yes. So so thank you for allowing this opportunity again. So Nikhil, if I understand it well, we have the definition of a specified purpose, and specified purpose cannot be infinite purpose. So even when we talk about applications or we talk about any body that is collecting data, when we define the purpose at the organization level for the objective, and this is where this is going to have a huge impact on the privacy policy or data governance of the organization. Your purpose has to be something which is measurable, which is identifiable, which can be said, okay, this is the purpose, or there could be a playground, a box drawn around that to say this is the specified purpose for which the data was collected. Because if the intention is so that once the consent is collected, once the consent is taken for a certain processing, and by the way, the definition of processing is very huge. Even storage would amount to processing. That will mean that if the purpose is not specified or purpose is too large, then that may not fall, or that may end up being in violation of the DPDP Act. So the purpose will have to be clearly defined by the organization. And yes, I agree with you that at this point in time, there could be certain parameters that could be given in the rules as to how the identification of the purpose should be made. Second, when we record the consent, now this consent, like we were talking when we initiated this discussion, this consent can only be for that purpose. You cannot bundle it. You cannot make it explicit, deemed, implied, whatever. And this consent cannot be stretched beyond the purpose. So, and if it gets stretched, then that is again violation of DPDP Act. And thereafter, let's say if a data is also collected and stored for all of legal purposes or all of any of those third party other elements for which the data is required to be kept, that will have to be differentiated. So while this data is collected, it cannot be like like we are saying, it cannot be collected forever. It cannot be shared forever. It has to be clarified. And if it is, even if it is, I mean, to me personally, reading the DPDP Act, I felt this is how it is. It cannot be stretched beyond what can be comprehended or beyond the meaning as it's conveyed by the definition.
So I can speak, about the storage part of it. Okay, because in the consent artifact in the account aggregator, you have that field called the data life. So when I'm, to give an example, when the lender is obligated to keep all my records for approximately, I think, 7 to 8 years. Okay, but the data life when I'm applying, for a loan would be say 15 days. Okay, but for 15 days, they can process my data to determine whether they want to give me a loan or not. Whether I take the loan, whether I qualify and rejected is a separate story, but the lender may be is obligated to keep my data, because when they get audited, they have to show that why I was approved or I didn't get a loan, but they cannot process the data.
I know my question more about continuous collection of data than anything else. Just wondering if anyone else in the room has questions, thoughts, comments.
Hi, thank you for the discussion. I'm Pundrakaksh from AZBN Partners. Just wanted to ask 2 questions. One, we just had ONDC, we've had OSEN, we've had a lot of public protocols. For the effective implementation of the DPDP Act, is that something that the industry would be amenable and would want the government to do, to develop like an open source public consent architecture, so to speak, which sort of implements all of these rights and everything? So that's one. The second is with third party, we spoke about Swiggy a lot. Is this the end of surprise deliveries? Because if I give the personal data of another data subject, is the service provider obligated to first give them a notice that, hi, I received your personal details. This is just being doing for this limited purpose. Of course, if you want to continue, then that's going forward. And finally, on the payments bit, in wherever the data is being retained for, for cross-selling, as was put on the panel, does that mean you're a data fiduciary for that aspect of the transaction? So to speak, and I'm borrowing again from the just-in-time notice situation, does that mean in the future, once I've transacted, I'm led to Razorpay, there is another notice that pops up that, hi, we might collect this for the future. You can opt out of collection on this front, but this we will have to maintain. Just those 3. Thank you.
Maybe the open standards question, Rajiv, would you want to take that?
Yeah. Paresh, you want to go? Please go ahead.
No, because, I want to say that actually, MIT has already published the consent artifact, the structure, the protocol, etc., which the account aggregator framework has implemented, and it is not specific to the the financial sector. So any sector will be able to use that framework. So that was the feedback I wanted to give.
Yeah, I think from the ONDC, public protocol point of view, and I think you alluded to consent managers in a public space also. I really feel that will be the next step of having open protocols for various businesses and industries. And there is an example of the sorts in National Health Stack that we have consent managers there. So there is some sort of precedence that is already kind of beginning to develop from a public protocol point of view. Similarly, for ONDC, 100%, be it Swiggy, be it not just food delivery, but e-commerce, retail delivery, or any kind of e-commerce business, there will be a volley of public protocols that would be required, not just from the extrapolation of where this is leading point of view, but also strategically, because I feel that ultimately, if there are only handful of protocols which are public or private, they may end up being monopolies of sorts when they become the gatekeepers. So it'll probably be a mix of both public and private protocols, and companies probably getting built on that. But at the same time, there should be a little bit of competition there, so that the purpose of ONDC doesn't get defeated in this whole maze. Yeah.
And Abha, maybe if you could comment on the question on surprise deliveries and what does the law mean that we can't do that anymore?
That's a very interesting question again, because I'm sorry, we keep going back to GDPR again and again, but there it is specifically addressed. If the collection of the data is through an indirect source, then right before the data is being used, earliest of it, right before the data is being used, or as soon as it is possible, the data subject has to be notified that their data is being processed. This sort of provision I have not seen in the Act. However, if I go by the definition of data processor versus data fiduciary, anybody who's determining the means and purpose of processing happens to be the data fiduciary, and the one processing on behalf of the data fiduciary is the data processor. So let's say there is an individual who's taken my data and who's wanting to place a delivery. Perhaps it'll have to be identified whether the delivery is fulfilled, which I believe happens today also, whether the delivery is for the person who's placing the order, or it is on behalf of, or for somebody else. That needs to be captured. Now, because Swiggy or Zomato or such other applications, they will be independently defining the means and purpose of processing this personal data in order to deliver that good or service. They become data fiduciaries. Now comes the question on when should the notice be given and how should the notice be given. So in the first place, maybe there could be a caution which says, or a checkbox which says that the person who's placing the order on behalf of somebody else has informed the other person, so that the recipient would be aware of something like this. And I'm sure, and this sort of will be in violation of the whole intent. But from a data processing standpoint, this information or this authorization or this approval will have to be there. Second, because the application that is delivering it will become the data fiduciary, will be required to process this data, will be required to keep this data for a certain period of time, and it belongs to a certain individual, the data principal. The data principal will have the right to withdraw the consent, and it is only possible, to enable this mechanism as required under the Act if a notice is provided. So right before the delivery, or otherwise, there could be different circumstances, it will be advisable that a notice is provided, so that the data subject whose data is being processed is aware of the rights, because that's the whole intent of the Act, and it's aware of the life cycle of the data, and it's able to manage the consent within the life cycle management of that data. That's my personal thought.
So the end of surprise deliveries, essentially. And Richa, if I could come to you then on the question on cross-selling and payments.
Sure. So as I mentioned in my previous illustration, when an individual offers for a buy now pay later, or for that matter, a customer has to avail of any offer. A merchant has to give any offer to a customer. So how does that happen? It has to, again, the bank has to decide that before they can give the offers, they have to, pass the data before the checkout page. So this entire mechanism, it needs some kind of a consent that needs to be given or taken from the customer, which is again not possible. So yeah.
Sure. And I think the question was also on whether the processor is becoming sort of a fiduciary in those situations. I think if you're acting solely on the merchant's behalf, only acting for the merchant, and you account for that in the merchant agreement as well, I'm not sure if you trip into that role. But the moment you start using it for your own purposes and you acquire the end user in your own right, there you run the risk of tripping into fiduciary status. I see there's a question at the back there.
Hi, everybody. Just to answer your question, I'm Ayushi Singh. I lead the privacy department for PayU. So when it comes to processing for cross-selling purposes, yes, in those cases, any type of activity which is independent of pure data processing, in that capacity, all of the payment aggregators are data controllers, or as you may say, data fiduciaries. Under these cases, either through the merchant journey or when the customer lands on your page, there would be privacy notices which would have to go up if they have to continue with this cross-selling, if they have to do data analytics. And even in the pure processing which happens, PayU does not, or any other payment aggregator for that matter, does not have the capacity of a data processor. It is always a data fiduciary. It is a licensed entity. You do risk check, fraud check, AML checks, risk profiling. A lot of these independent activities take place when a user profiling is done. Like Richa said on the BNPL model, BNPL is more in a financial services sector. Even for payment processing, we have a lot of transactions. There are fraud checks that have been done. In those cases, since it's a licensed entity, the nationwide, it has always been a position of payment aggregators across that it is a data fiduciary at all points of time. We may have customer information, which is PI, which we will use only for the purpose of payment processing. But when it comes to sensitive data, even in the processing leg, all of these payment processors act as a data fiduciary. They don't act as a data processor.
Sure. But in those situations where you may only be executing the payment transaction, wouldn't you continue to be a processor in those areas limited to those?
Once you get the information, at that point of time also, you have to do KYC checks, you have to do AML checks, you have to do fraud checks, right? In all of those capacities, you're processing the information. So in the entire life cycle of payment processing also, you are never a payment processor because you're taking acts and doing processing, not on behalf of the merchant, but on behalf of the customer, also on behalf of what the regulator has asked you to do. The regulator has given you rights and obligations of a controller. And in those cases, when it comes to PI, name, email ID, yes, it may be a data processor. But when it comes to sensitive personal data for processing of the transaction, as an aggregator, the person would always be a data controller or a data fiduciary.
Prashanta, do you want to also come in there?
Yeah, I can hear you.
No, so I had two quick points. One of them was just covered. PayU is a data fiduciary, so are networks like Visa, MasterCard, etc., not a data processor. One of the reasons is they also determine the purpose and means of collecting the data because there's certain types of data they need for AML, etc. That's one type of it. The other is in the same extension of that example, you were talking about on behalf of the merchant, but the merchant is not the data fiduciary. That is the acquirer or the issuer. Okay, the merchant has no role in it. The merchant has nothing to do with determining the purpose and means of collecting the data. Merchant just offers a machine or a QR code or whatever. So that data fiduciary is either the acquirer or the issuer. And then the network can also be the data fiduciary, and the network can have a role as processor, but usually the fiduciary, as I think is covered. That is just a point.
But in situations where, say, like loyalty programs, yes, of course, when it's the network itself, but if you are only sort of, determining the purpose and means also, of course, the methods, all of those you're determining when you're, say, doing fraud checks, all of that you're doing as a regulated entity. But there may be situations, right, where your primary purpose is not independently acquiring the customer for your, it's at somebody else's behest that customer has come to you in the first place.
Yeah, that's true. But when we've looked at this closely in the context of the card networks, and I think it'll be the same in this, there is so intensive involvement of that network in determining the purpose and means of collecting the data for their very detailed AML. They're responsible if there is fraud. They give a fraud score back based on information they collect. So we see very little scope for, any sort of waiver of liability as fiduciary in any context. Everywhere
they might not
it
want to do that either. You do want to have the customer in your own right, but it's the question of opportunity to give notice, consent.
Yeah. The interesting thing is that at least with the card networks, and it may be true here too, they don't necessarily collect the identity of the person. Okay, the name, address, etc. remains with the issuer bank. The network actually gets a certain filtered set of things, but it determines what those are.
How are we doing on time, Aarti?
Sorry, we have 8 more minutes.
Sure. Go ahead.
Hi, Arjun from SFLC Legal Counsel. My question is on notice, and while we understand that apart from the huge host of information obligations that are there in the GDPR, we have in ours the notice provision basically talks about the providing of two rights, and that is of grievance redressal and the right to withdraw consent. Do you think there is any rationale behind not including the other two rights that we have, that is to nominate and access, more importantly? Because as a user, I will be more interested or as interested about the information or the data that an organization has, whether even if it is a summary of it that I can access. But if I'm not told about it in the notice itself, do you think that that has a bearing on transparency?
Rajiv, what do you want to?
Sure. I think if I understand your question correctly, what you're alluding to is the data that is there and the purpose of it should be transparently, or in a very transparent fashion, be told, so that there is a easier actionable to it, that you could retrieve it or revoke it. Is that the question that you're asking?
I'm saying that in the notice, it's mandated that the right to withdraw consent and the right to grievance redressal is mandated to be provided. The other two rights, to nominate and for access and also for erasure, are not mandated in the notice. Do you think that has an?
I think no. I get what you're saying. So I think from the immediate rollout of the act and therefore the rules, I think the nomination and the access may be the secondary implementation, or they may be an addendum to the rules, let's say, in the future. But I think from an act point of view, the first two are more important when it comes to issues that will arise or not arise because of. So I think from just an immediate implementation of the act point of view is what I feel. For example, if you're looking at healthcare data, right? I think from putting guardrails on withdrawing or accessing may be a little more harmful in the initial stages of the act rather than having them, right? So that's what I would feel, but others can add here too.
If I may, just to share a bit on this. So let's see it this way. When the notice is provided to the data subject, and if I may request your attention to the act, it says that the notice is going to contain a certain list of elements. These elements are the personal data that is collected, the purpose for which it is collected, or the purpose for which it is going to be processed, the manner in which the data principal may exercise her rights under subsection 4 of section 6 and section 13, and the manner in which data principal may make complaint to the board. So let's leave the third one, the first one and the second. So one, the purpose is provided to the data subject. Two, the list of rights that the data subject has. This list also includes that the data subject has a right to withdraw consent, has a right to nominate, has a right to access the information that is processed by the organization about the data subject. Let's also look at another interesting scenario. It may happen that the data of the data subject could be collected over a period of time. So when the first notice is given, or the notice could be required to be given at different stages, because different kinds of data could be collected by the data subject, right? So it is, I think, by this provision of right to access being there at all times, right to withdraw the consent being there at all times, and right to nominate at any stage of the data life cycle management, makes it more comprehensive and makes it more holistic. Again, this is my personal thought. Please feel free to differ. I just share it with you as it comes to my mind.
Just one last question before we wrap up. This is from Aditya, who's tuning in online. He says, according to section 5.1, notice should be accompanied with or should precede a request for consent. However, the DPDP does not set out any other instance where a notice is required to be provided. Are data fiduciaries only required to provide notice when relying on consent as the legal basis for data processing? Is a notice not required when relying on other legal basis? Is this something that should be clarified in the rules?
Would anyone want to comment on that one?
Hi, if I may again answer that question,
Yeah.
there are only two bases of processing: consent and legitimate use. Consent, we are clear, you have to have a notice. It can be processed only after a notice is provided. If you look at legitimate use, the interesting part in legitimate use is that while it says that the data subject has voluntarily provided the data and has not indicated that the consent is withdrawn, but then it again talks about specified purpose. Now let's go back and look at the definition of specified purpose. And as far as I can recollect, the specified purpose again says that it is the purpose for which the notice has been provided to data subject. So according to me, in both the circumstances, there are only two circumstances of processing personal data, only two bases of processing the personal data, and on these two bases, the data subject has to be provided with a notice.
So Abha, you're saying either consent or when it is
Or
voluntarily you're providing data. Of course, there is obviously that opportunity to also give notice in both of these situations because you're actually actively collecting the data from the individual. But there's also 7B to which, all of the other 8 legitimate uses that are recorded there, including purposes of employment. There strictly the requirement of notice hasn't been coded, is not set out as required there. I think that means no notice is actually required to be given.
No. Again, no. There is a reason for that carve out in the context of employment. The reason is that across the world, we have this consensus that employer and employee cannot have the same bargaining power. If we look at the definition of consent, it is to say it is freely given, unambiguous. There is no, the parity of negotiation, the power of negotiation exists. So in terms of employment, and before I go that, I will draw your attention to the preamble, which says the purpose of this act is to recognize the rights of individuals, protect their personal data, at the same time process the personal data for all lawful purposes. Coming back to the context of employment, organizations have a legitimate interest in protecting their intellectual property right, in providing security to the workforce, and in securing so many other things. Does it mean that I can put a, say, camera and not tell the data subject that I have put a camera and I'm going to monitor you 24/7 or as long as you're there in office? Again, this will not fly through. This has happened like in across many jurisdictions. We have seen this sort of conflict, and everywhere it says that whatever means and measures are deployed, you cannot have consent for basis as the basis of processing an employee data. This does not mean that you dispense the need of providing them the notice. And this notice, or whatever means and measures are being deployed, or whatever is the purpose of processing, it has to be so, an information of this has to be provided to the data subject, and there has to be a proportionality between the means that is deployed and the objective that is sought to be achieved. And this objective cannot override the right to privacy at all. It will never stand the test of time. And this is exactly what was echoed in the judgment of Puthuswamy, where it says it is inherent, right to privacy is inherent in right to life in Article 21. So any means or measure cannot override right to privacy or right to life. But it will not mean that a notice is not provided. When a notice is not provided, there is absolutely no transparency at all, and that will defeat the whole purpose of processing under this act.
Sure. I think the question is coming from the perspective that the section is actually not requiring for that notice in these circumstances. But I hear you that there are also generally there's a requirement to adhere to organizational technical measures to give effect to the law, and we sort of read that alongside the preamble as well.
Yes, and just the last point, and this that I share with you about between an employer and an employee. This subject has been debated in a lot of jurisdictions in Europe, in US, across, and there are guidelines that have been released by a lot of data privacy commissioners and data privacy officers, and all of them are clear about this one point, that you cannot process data which overrides right to privacy, which does not have an objective, which is not in proportion to the objective. Transparency, on the contrary, if there's transparency where there is accountability, where the processing is transparent, this will have more of buy-in from the data subject, irrespective of where the data gets processed.
Sure. Nikhil, were there more questions?
So
or-
we're running
Okay.
really out of time. There are two quick questions. If we can get super quick answers, that will be great. Saraswati, you have the questions?
Yeah. So there's a question from Sachin Dhawan who has joined online. Even if data principals are able to understand the terms contained in a notice, they will be faced with take it or leave it terms. Is there some constraint on including take it or leave it terms in a notice? This is the first question. The second one is from Teresala Paul. Notice under section 6 is only required for active consent, but access rights, etc., are available for deemed consent as well. That is section 7A. How would the data principal know what data is collected under 7A as a legitimate use?
Sure. I think the second one also speaks to what we just spoke about with the notice requirements, sort of that when you have the opportunity to interact with the individuals, sort of let them know that these are the things that they're doing with your data. But maybe on the first one, Rajiv, would you have a thought there? Abha, do you want to come in on that one?
I'm sorry if you can, it was on consent. I'm sorry, can you just repeat that question?
Take it
If you
or
don't
leave
mind.
So
Take it or leave it, yeah.
Take it or
So
leave
if you
it.
look at the act, yes, if you look at the act, now there is certain data that is required for a service to be delivered. And if you look at the act, there is an illustration which says that if you do not provide, let's say you've ordered something from Amazon and you do not provide them your address or your phone number, you will not get the delivery of it, right? So it is not take it or leave it. It is essential for that good or service. The larger question is that can I draft a policy to say that there are like, I'm going to deliver you this product, I'm also going to profile you, and I'm also going to sell your data to a third party? I can't do it, because my purpose of transaction was to deliver the product to you. So when I deliver that product to you, my purpose is finished. Now if you do not give me the consent, I will be denying you a service. Can I deny you a service? Not under the act, but universally, no, I cannot do that.
I'm wondering, Mahesh, if you also had thoughts on that. Consent, I mean, purpose is actually not, whenever we talk about purpose in the act, it's a specified, when
Yes.
it talks about consent, though it talks about specific. Mahesh, if you had any last sort of closing thoughts, and then we'll wrap up the session.
So see, you put it very well, Abha, but I'm just saying in the financial sector, so I am shown if I am going to take a loan and the lender is going to show the consent to me that that they want 8 months of my data, and the purpose is lending and the data life is 1 month. So over here, according to me, it is take it or leave it. I mean, if I agree with the terms, I will say, okay, I'm applying for the loan. If I'm not okay with the terms, I will reject the consent.
With that, I think we'll close the session. We're well past time. Thank you so much, Rajiv, Abha, Mahesh, and Richa, who's just left. And thanks, everyone.
Thank you, everybody. Thanks for having me.
Thank you so much. It was great talking to all of you. Bye.
All right. Thank you so much, everyone, for that great discussion. And the next panel that we're looking at, this is a room full of grown-ups, but this panel essentially looks at like what will the next generation of internet users actually face online, and that's children. The act, does deal in some depth with children's privacy rights online, but fundamentally, how will those provisions impact businesses and the kinds of services that they offer to kids? So to moderate this panel, we have Aparajita Bharti from the Quantum Hub. And speaking today, we have Manasa Venkatraman, Uttara Ganesh from Snap, Nidhi Sudan from the Citizen Digital Foundation, and Sonali Patankar from Responsible Netism. So if the panelists could please take the stage, that would be amazing. Thank you.
Okay. Hi, thank you so much for inviting us to speak about what I think is the most contentious part of the bill. Law. Sorry, I'm so used to calling it the bill by now. We are going to talk a little bit about children's privacy. And we have two panelists online also, right? Nidhi, Sonali, are you here? Can you hear me?
Yes, hi. Can
Yes,
you
yes,
hear me?
absolutely.
Great, great. 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 So I think before we get into the discussion, I know that a lot of people are already aware of what's there in the law, but I just want to refresh everybody's memory. The law requires verifiable parental consent for processing data of data principals that are below the age of 18 years of age. There is a ban on tracking of children's data and also on targeted advertising. There is room for exemptions on some of these provisions or all of these provisions for certain purposes or for certain fiduciaries or for certain classes of fiduciaries. And a lot of it is actually left to the rules on how these exemptions could be potentially taken and how verifiable parental consent will be taken. And this is what we are hoping to discuss today. We have a phenomenal panel. We have Uttara from Snapchat, Manasa, she's a privacy expert. We have Sonali and Nidhi, who actually work with children who have faced a lot of issues online and they work on children's safety. And I'm so glad that we also have that voice on this panel because sometimes they are dealing with cases where children are actually really kind of facing the brunt of some of the issues that they face online. Great. So Manasa, I'll start with you. I think this debate is happening all across the world right now. Every day we wake up with something around parental consent and how age verification needs to happen. In that global context, how do you think India's data protection law now fares? What do you think is good or bad about this? And sorry, I'm asking like a three-part question, but it is what it is. And what do you think the rules need to tell data fiduciaries so that they can actually comply with the law?
Thanks, Aprajita. And it's great that you've asked a three-part question because now I have the mic and I can go on for however long I want. So in terms of what the law, I'll answer it this way. I'll first talk about the four different sub-themes or subcategories that are there within Section 9, how much they align or are divergent from global standards, and whether that's really a good thing or not. And the opportunity that this leaves for us with respect to future-proofing the regulation as a whole. Section 9 is so packed that I like to unpack it by looking at, by dividing it into four categories. The first is age of consent, which, like you've said, is set at 18 in the Act. World over, I can't think of a single law where an age of consent is provided and it's not an arbitrary age. So this could be 13, this is 14 in Korea. The GDPR sets it at a band between 13 to 16, India sets it at 18. But it's always an arbitrary age. And that's not any better than not having an age of consent at all. What would have been better, and what we still have an opportunity to do, is introduce a sliding scale of consent. And this ties in with the parental consent framework that will come up under the law. Individuals below the age of 18 are not one homogeneous bunch, as the two experts that we have online will tell us. They are at different stages of maturity and they have different needs and therefore different levels of parental observation and intervention to ultimately give them the autonomy that they will need once they turn 18 and have to consent on their own. And so a sliding scale of consent, which is being explored in, which was explored in the US, and it's a debate that's kind of picked up once again with COPPA 2.0 being heavily debated over there, is worthwhile for us to consider. Similarly, with age verification, when we think of age verification, we instantly think of like, okay, I'll have to upload a photo of my Aadhaar card, or I'll kind of have to provide my date of birth, and I'll be allowed access to a digital platform if I'm over the age gate. But age verification is actually far more technical than that. There's a lot of very sophisticated mechanisms that are coming up, which are also privacy protective, which are ephemeral, tokenized, and still provide a certain level of autonomy to guardians as well as individuals, as well as minors, to kind of surpass the age gate and move forward. I will pause here, and then I'll kind of answer the other two parts of your question.
Great, Uttara. So as a platform which has a lot of young users, how are you thinking about implementing this provision on the basis of what we know right now? What do you think are the challenges, and what do you hope the rules sort of demystify for data fiduciaries to comply?
This is turned on. Okay, great. No, thank you for the question. I did want to level set by saying, Aprajita, you were right in saying that this is a complex problem. And I think it's complex and hence not resolved at the moment, right? And as Manasa has also just said, this is not an India conversation, it's a global conversation. And I think what we've learned over the last many years is that there is no single silver bullet to this problem of ensuring children's privacy, especially from the lenses of like parental consent and what that sort of assumes, which is verification of some sort, right? So there is no silver bullet. And from Snap's perspective, I think when we're examining solutions and thinking about compliance, what's becoming very obvious to us is that no matter what route we take to ensure compliance, there will be some sort of difficult trade-off to make, right? So in terms of challenges with regards implementation, here's what we're seeing. Okay, and I'm not privy to the technology you mentioned, Manasa, which is ephemeral and tokenized. I'd love to learn a little bit more about that. But from the options we're considering, right, I think the first insight is that the tech at the moment that ensures verification, while promising, is not foolproof, right? What are the options available before us? There's self-disclosure, which is easily circumventable. The second is, of course, ID-based verification, which we know, of course, has data privacy risks. But then also, you know, the trade-off there is that some people may not even have IDs. There's an access versus accuracy trade-off there. The third is, of course, using biometrics of some sorts, which some experts think actually might be quite fine from an accuracy perspective. But then there are variances because of things like skin color and your physical features, etc. The level of perfection in those technologies are limited as well. Right, so the tech is imperfect, number one. But beyond the tech, right, this is not just a tech problem. There's a broader issue here about a whole of system sort of what can each person play. The central question from our perspective also is the preferences of teenagers or the behaviors of teenagers and young people in general. I think that the reason circumvention is such a real problem is because teenagers don't want to be excluded from using digital services and from vast parts of the internet, right? And therefore circumvention exists. There are studies that in the EU that informed some of this insight, but I feel like what our community could really benefit from, the Data Protection Board could super benefit from, is some really considered research that studies the cultural nuances or frankly, the aspirations and behaviors of young people in India, and help that inform the rules, right? Of course, it'll also serve in a big way to inform platform design, because then we can think about circumvention, how do we negotiate this preferences? It's a complex question, but it's an important data point that I don't think we've had, right? That is India specific. And the third thing I'll say in terms of challenges is just, and I won't, sorry, it's a bit of a monologue, but the third thing I'll say in terms of legal challenge, right, is two things, especially as a global company. We think it's very possible that there are contradictory guidances issued by governments on a couple of different things, right? The first is on what is a shared understanding of a risk taxonomy, right? I feel like maybe the EU has a different point of view on risk than India. And as a company that's globally sort of present, negotiating that is a bit of a nightmare, right? We're going to have to figure out how to work this out. And the second thing is, what about also the technology, right? For instance, I totally imagine a world in which the EU is very okay with, very not okay with using biometrics as a means for verification, whereas maybe India is like, yeah, let's use DigiLocker, right? And therefore, having different mandates from different countries on very specific parts of this complex issue is going to be problematic, right? Similar, I mean, the same thing lies also for DPIA risk assessments. We can talk about that in a second as this conversation evolves. But I think, yeah, our main concern is that this is a more complex problem than we realize. And I think jumping straight into this architecture is perhaps a bit too quick-footed, right? And we need to be a little bit more considered in our approach.
But do you think there's policy space to be able to push back against this age of 18? Because this is a conversation we've had in the last PrivacyNama and the last PrivacyNama as well, that the age of 18, does not make sense. There has to be a graded approach. How are you seeing the policy?
Yeah, it's a good point. And I for what it's worth, okay, I think all of us should be a little bit more hopeful because the last PrivacyNama, there was a 9, 4, and 5, right? Which basically says that depending on, what does it say? Okay, I have it in my notes here, but essentially it says that depending on the nature of the service and the risk it posits, right? And the nature of processing, you can lower or readjust the age for which these requirements you need parental consent, or there's a prohibition on behavioral monitoring. So that to me is a glimmer of hope. And to me, and maybe I'm an optimistic person, but it sounds to me like that is an opportunity to make a persuasive case for a risk-based approach. Now, what does a risk-based approach look like? I don't know yet. I think we should all talk about it together, but it's going to be a bit of a political freak. It's going to be a difficult conversation, but we can talk about it as this evolves. Yeah.
Okay, great. So Nali, are you here? Sorry, I'm not able to see you, so it's a little bit disconcerting. But can you hear me?
Yes, I'm here. I can hear you. Yeah.
Great. So, Nali, since you work with children who are actually sometimes in conflict with the law, or children who've actually faced online abuse, or they live in atypical families, because I think this law assumes that almost all children live in typical families where parents and children have a certain kind of relationship. Do you think this overall reliance on parental consent is the right way to go in general, or do you think that there needs to be more safeguards for children's privacy? I would love to know about that. Yeah. And then I have a second part.
Sure. So one is, thank you for having this conversation. I think it is critical for people to understand what data and consent is all about. And thank you for having me into this conversation. Honestly, I feel consent is extremely underrated, and the power to consent is terribly undervalued in our country. So when a population of 80% adults do not know what consent is and is distributing data like Prashad, how are we expecting our children to understand privacy, consent, or data and its protection is something that I really fail to understand. I also feel very strongly adults themselves are unaware about what data and what consent is about, and therefore it is shared so commonly in various platforms, and there are no boundaries created. And while we work with children, we're talking about safety boundaries which are not spoken about at all. So we believe while 80% of the parents don't know what their children are doing online, which means the consent completely lies with the child between the age group of 13 to 18 to navigate, to understand consent, to understand data, to manage his or her own safety. I think it is too much to expect from a child when there is no education coming in on that front from any perspective. And I think that is where we bring in children in special situations or children needing special requirements, where they belong to the most vulnerable of the vulnerable categories, and they seem to have absolutely no understanding of where their data is and what is going to happen to it. I'm even wondering whether we have systems in the government or within the child protection mechanisms where such data is preserved and very consciously used, because we've had various instances of this data being distributed on very open platforms, used as a tool to communicate. These norms need to be set very clearly for children, and we cannot let this onus be on the child for sure.
And how do you feel now? The law basically is actually putting the onus on the parents, right? That is why the law is saying that you need verifiable parental consent. So while you're absolutely right that children are not possibly in the right sort of, they are not able to make these decisions. Do you think parents in these situations are able to make better decisions, or do you
I
need?
would say that only in about 20% of our country's parents, because they probably are literate, they are digitally probably aware, but 20% of parents. But the remaining 80, I feel they're under the category of giving assent because they don't know what they're giving consent about or for. Consent legally implies to anybody over 18, but if you don't know what you're consenting for, makes no sense whatsoever. So when a child is giving consent, he's on his or her own for a particular platform to be on that platform, and the parents are unaware, who takes the responsibility? And parents really don't know how to use devices. So digital literacy is a different challenge altogether. One is they are first generation internet learners. So consent comes to them 25 years down the line, while their children have already navigated in the cyberspace and been there, done that. So I think these need to come in. So I very strongly believe, and I want to put across here, that consent needs to be taught as a life skill for children from age 6 or even younger, because that is when the exposure actually begins. And which means consent needs to be taught to parents before children are born. And we need to, work backwards now, because it's high time that we get parents involved into conscious decision making. I just want to give you one example, and I leave the others to talk. It's not only about social media platforms, it's also about what you consume on televisions. So if a 5-year-old is watching something horrible, apparently with consent, where is this consent coming from? Who is giving it? Who is making that conscious decisions within the family? So it is a very blurred. I'm glad that there is a law so that we can bank on it, but I think we need to start on a war front on teaching this to people.
Great. Sonali, I agree. We also work with, young people from low income communities, and a lot of them actually use shared devices, and, parents themselves are relying on children to actually learn how to navigate these platforms. So our law has kind of reversed this dynamic, and we can talk a little bit more about it. Nidhi, I think this is a great time for you to come in, because you also work a lot on digital literacy and with people, with low income communities. And I was struck by your work, which says that making platforms work for you. So where do you think this responsibility should lie between children, parents, platforms, and what do you hope to see even in terms of changes in the law, but also maybe platforms as well, that you think would keep children safe?
Thank you, Aparajita. I hope my audio is clear. There could be a bit of echo. Let me know if there's a problem with that. Great to be part of this conversation. And thank you, Manasa and Uttara, for setting context from the law's perspective. And Sonali for beautifully stressing on the aspect of consent and why it should be ingrained in our cultural conversations to begin with. I will just come in with the aspect where I think there's a little bit more gap than that I could probably, contribute to. So yes, we interact with end users and non-tech end users of technology. And at the same time, we also advocate responsible tech to businesses and government entities. So in our experience in the last 2 years, we have seen a huge evolution in how people's understanding of online technologies have changed. So when we started off, there was zero perceptiveness around the importance of data privacy. Everybody was absolutely fine with the convenience and mesmerizing experiences that were being brought into our lives. And that was about the period of the pandemic where we literally needed the technologies to even, stay sane, be educated, learn, and everything else, right? So there was no, openness to the flip side of what could be going wrong here. 2 years down the line, we're seeing a lot of fallouts at the non-tech end users level. And there's a lot of conversation that is coming up from end users saying that we don't know how to manage this. What is going on? Why are there so many other side effects? You know, mental health challenges, harassment, and children being addicted to screens. What's going on? And parents, I'm going to come back to the bit of parents because Sonali's rightly pointed out about children and understanding consent. Aprajita, you asked specifically about how the law puts disproportionate onus on parents, and that is right. I completely agree. Parents also do not have the wherewithal to understand how sophisticated these interactions can be based on the data that we submit. And this is not even PII or basic demographic or, you know, financial data. The behavioral data is what I'm talking about. How it can be used, you know, factoring in the interoperability of the ecosystem and, you know, the basic 5 or, you know, 6 big tech platforms that essentially decide the knowledge and information ecosystem, or, you know, how people make sense of things. It's too ingrained in our culture right now. And at this point, you know, taking back or setting a law which kind of, you know, says that parents have to now give consent to for children's data is a lot of action in retrospect, which I have cynicisms about in terms of practicality. Because like Sonali also pointed out, children are into the ecosystem way more than the parents are. And when there is a knowledge gap among parents, you know, despite the literate urban parents knowing a bit more and being a little bit more concerned, the nuances still evade them. And when there is a knowledge gap and you have a law that says that it is the parent's responsibility to give access, then we are suddenly saying that you know, end users or parents have to suddenly become really aware and literate in the aspects of what is going to be done with the data, which nobody is teaching them. Or, you know, they don't even have the motivation or the bandwidth to even go out and learn. So if I, as a parent, am faced with a VPC, a verified parental consent protocol through an architecture of the, technology platform that I'm interacting with, saying that you need to now grant consent for your child, I will just do it for the heck of it. I'm not going to like think about it too much as to what happens. Possibly over a period of time, this might get red flags going in parents' minds that, okay, suddenly platforms have started asking for my consent. What is wrong? Is there something to worry about? The red flags might also happen. But I do have recommendations. I think I'll come back to the recommendations on what exactly could fill the gap here later. I'll also be happy to listen to more of this conversation and how it evolves and then come back to that.
Nidhi, actually, I want to ask you now only what recommendations you have, because I think we all have the diagnosis of the problem. I think I went to a woman MP, I can't name whom, and I was just talking to her about this, issue. And she was like, this is the law. My child will just make their own email ID and they'll give consent on my behalf. It took literally less than half a minute for her to understand that this is not going to get implemented very well. So I think everybody who's interacted with children, but even then she was like, that was my point also. She was like, our children already have access to all our IDs also now, because they keep getting linked here and there. So she was like, this is just not going to work. That was her this thing. So Nidhi, if you have some solutions in mind, please do share with us.
So just looking back at the COPPA framework and how they have a few set of, the telecom based or phone call based or, credit card and identity related approvals for parental consent, which is verified. If those processes are set in place and linked only to the parents' IDs, keeping aside how children can kind of circumvent that, it requires another intermediary between the platform and the parents to kind of give a certification of some sort. And I think this conversation has been going on globally as well. Is that if the parent knows that this is like ISI or FPO certified based on, okay, if I consent, I know that the data that my child is going to submit is going to be used in safe ways, the necessity, proportionality aspects, everything is taken care of. Then as a parent, I don't have to do the due diligence to kind of go and find out, nor does it become a convenience nightmare for me or my child when it comes to accessing important technology to be able to develop as such. So there have to be intermediary bodies that typically work to certify that this organization is kind of legit in the way it processes the data, and then have end users have a clear access to, okay, this has been, kind of certified in this way, and therefore you can go ahead and give consent, if that makes sense.
Great. Nidhi, I'll come to questions. Manasa, I want to come back to you. Do you have any reaction to, I think what Nidhi is alluding to is setting certain standards so that it becomes easier, and this information asymmetry between data fiduciaries and parents who are consenting on behalf of children is taken care of. This is a bit like age appropriate design code, but maybe a different framing for it. Do you think this would work in the Indian context? And if it would, how would that be actually enabled or implemented? And who would certify? That's a big question.
I'm not sure. I'd love to hear Nidhi's thoughts a bit more on the certification bit that she spoke about, and the learned intermediary in between that she spoke about, because that sounds a bit similar to what's already being imagined with respect to the DigiLocker. But to come back to your question, Aparajita, I completely agree that there is a huge gap. There's a huge information asymmetry between parents, between the minor that wants to access the services, and the myriad ways in which data is collected, voluntarily provided data is collected, and also the data that's observed about an individual once they're on the platform. I agree with Uttara and I want to emphasize once again that step 0 is really figuring out how big of an information asymmetry this is, and setting the onus very clearly on the regulator that's actioning, or that's kind of setting the frameworks, as well as the data fiduciary to try and bridge this information gap. Going back to the age-appropriate design code, what comes to mind is the phrase, data must be collected and processed in the best interests of the child. Since 2018, I know that several stakeholders have kind of gone to the government, gone to bodies that have been constituted to kind of emphasize that it's important to bring this phrase in because it's a global standard. And that's really, that would have laid the foundation very beautifully in terms of helping jurisprudence develop in India, and would have allowed us to benefit from what's happening on the best interest framework in the Western Hemisphere. For example, if there is a conflict between best interests of the child or processing that has to be curtailed because it's insidious and not in the child's best interest, if there's a conflict between that and commercial interest for the platform, the best interest of the child prevails. It takes a leg up. So setting those principles at the very foundation, and then working up from that to build to bridge the information gap between parents and what they're required to consent to is really step 0. In terms of,
do you think there's space in the rules for this still?
I think so. Like Uttara, maybe I am also too optimistic, but I definitely think so. And the reason I say that is because of the silver lining that's provided in terms of subsections 4 and 5. There's room to not just, of course, this takes the conversation into a bit of a tangent because that talks about exemptions. But there is space in the rules to kind of carve something out from the ground up. To carve not just technical standards, which I understand are a little ways down the road, but principles-based frameworks, depending on the Indian context. And I'd just like to leave with one thought before we proceed forward. Time and again, through the course of consultation on the PDP bill and now the DPDPA, the government has expressed a desire to be distinctly Indian. There's been a dislike to being compared to the GDPR, to Western regulations, almost a resentment when these comparisons have arisen. And that's not necessarily a bad thing. This problem is a distinctly Indian problem. And it gives us room now to build a distinctly Indian approach to solving this problem. We have the benefit of rules that have emerged across the world. We have the benefit of leveraging Indian technology that is emerging. And so it rests upon us to build frameworks that are principles-based and that are based on risk.
Great. Yes.
So in Feb this year, we've done a discussion on the scale of where users can be anonymous to where users need to be identified biometrically, where there's room for anonymity, room for pseudonymity, room for... So we looked at that as a verification framework, including where a verification value that might be 0, as in no verification required. Does the law still leave room for that scale to come into operation? And you're talking about a risk-based framework. We had looked at it from a harms-based framework, that there needs to be proportionality to harms. So does the law in its current state allow us to actually explore such a framework, given that verification is now potentially required for all users and not just children because of this clause?
That's interesting. I would say yes. And I would say
because
that...
you're being optimistic.
So I'm a positive thinker. There is room to develop standards for verification. There's room to develop principles-based frameworks for verification, because Section 9 doesn't use verification at all. It only says minors need to obtain verifiable parental consent. But that's just a half of the problem. Age gating needs to be solved in to allow a minor to access digital platform. Age verification as well as parental consent are both important. And because of that, there's room to develop a spectrum of verification mechanisms, pseudonymized, biometrics-based. There are a few wacky ideas out there, cryptography-based and
But
facial
the very fact that you have to do verifiable parental consent means that every user needs to be verified so that you're able to authenticate whether there are the minors or not, right? So verification across the board is here upon us by virtue of this law. And so therefore, is there a sliding scale that can be in operation where verification can be starting off with email-based to all the way to biometric authentication? Or do you think that the envisioning of this regulation is such that verification specifically means biometric authentication or DigiLocker-based, Aadhaar-based authentication?
So I could try to take a crack at that. I don't think there's one silver bullet answer for verification. I think we know at this point in time that not any one method is foolproof, right? So it will have to be a basket of solutions, right? And to your point, Nikhil, I think, to me, the sliding scale approach looks a little bit like this, right? We need to sort of identify what are high risk or high harms or use cases or platforms that caused a lot or have high potential for harm. And within platforms also, we need to look at specific functions that have higher possibility of harm than others, right? And the rolling out of the verification mechanism and the type of severity of the mandate should be proportionate to the level of harm and the level of risk, from my perspective, right? So for instance, every platform is differently designed. Every platform has different functions. And within the platform as well, for instance, you might be, some platforms enable chat one-on-one and some enable communication with several people at once. So depending on the type of function, we'll have to come up with a taxonomy. Now therein lies the complexity.
So you're saying there is room to play with the word verification. That's pretty much all we have right now.
I think so. And I think, see, if it's a use case that isn't so, if it's a platform that's only, like a one-way, content for young people, for instance, and there's no interaction, that's less risky than a place where there's chatting involved, for instance, right? So maybe for just consuming content, you need to have a different type of verification method. Whereas if you want to enable chat, or if you want to enable speaking with more than one people or participate in a group, maybe that requires a higher threshold, right? It's really complicated because our platforms are so varyingly designed. right? But we will have to come up with a framework that sort of situates that complexity.
So we are hoping for nuance in policy making.
That is the hope, yes.
I think we'll come back to this question about DigiLocker, etc. also. Sorry, just one thing that we haven't touched upon is when government is the data fiduciary, because government has a lot of data on children. And there was the APAR ID that was just announced, I think, last week, which is going to aggregate all of student information, and it's going to be an interoperable system. And Sonali, I want to come to you because, you work with children in conflict, and many times that data is actually with law enforcement itself. So in your, whatever work you've done with the government, do you think government is equipped to protect that data itself? And what kind of responsibilities should be there on the government also to protect the data of children that they have? Because one of the things that is there in the act is that government can give itself any number of exemptions when it comes to compliance with this law. So I'd love to know your perspective on that as well.
Yeah, so it is not just data of children in conflict with law, it is data of all minors that is there with the government. So the entire school list, we have lakhs of schools in our country, the entire data of school children is with the government. There are mechanisms to control it, but there is no awareness on what needs to be done. I think understanding how to protect data systems, even basic audits, computer audits in schools, in organizations or in institutions that are dealing with children, the awareness on that front is very, very low. So I think as stakeholders, critical stakeholders of child protection, the entire mechanism needs to be equipped with skills to protect children, understand what is crucial, critical data, and also understand where, how, and what not to be shared. Let me give you an example. A lot of times when CSAM cases are reported, we've seen those videos being circulated just because people don't know what to do with it. When the law strictly says that you cannot circulate, store, or distribute any form of CSAM content, that is because of lack of awareness, and also because of the lack of awareness of what to do when you receive such kind of content. So I come back to the point of creating awareness about preserving the data that is existing through cybersecurity or audits, or those systems that need to be developed. At the same time, understanding boundaries in terms of what to share, where to share, what not to share. So, for instance, even though a platform is convenient to share or communicate with, that does not mean you send a GR on that platform, or that does not mean it allows you to share a picture of a child in conflict to another colleague or to anybody in the system, because that violates the privacy of the child, and it also makes the child more vulnerable. I also have another situation that we were very stressed with, where in peak COVID times, there were these two children who were abandoned and who were orphaned because they lost their parents. And this particular situation was reported saying that these children need help. And by the time the government could actually reach the children, they were trafficked, because all the information that was required was available on social media. And these people probably reached the children far earlier than the systems could reach to, protect children. So that is how vulnerable the internet platform is for children today. And therefore, understanding the responsibility as a child protectionist is extremely important, and that needs to be a part of the training in every mechanism or the system of people that work with children.
I think the child protection ecosystem itself requires a very separate kind of guardrails. And I think the point that was being discussed in the last session, that having codes which are sort of specific to the kind of fiduciaries, because when we are thinking about data fiduciaries, most of the time the conversation ends up revolving around social media platforms, etc. But the child protection ecosystem itself is such an important part of actually protecting children. So how do they deal with data that is with them? And also right now, without exemptions, tracking for them is also banned. So like, somebody who operates a child helpline, they were like, how do we help a child unless we can track, if they've got the right help, etc. So definitely exemptions for these kind of use cases are required. Great.
So-
You have a question.
So
Yeah.
I am a content creator. My name is Saurabh Jain. I am founder of Fun to Do Labs. We are a edtech company. Now the problem is that COPA and all these things are applicable to us. And recently we published an app on iOS, and Apple was not passing the app because it had Google Analytics. Now the problem is that without Google Analytics, how can I know who is using my app in what way? So at least I don't want the name of the child. I don't want the details of the child, but at least I want the city of the child, as well as I want the, like, is he or she playing level 1 in my game or level 2 in my game? I need that kind of anonymous analytics, but due to COPA and all these things, these are not allowed. We also run a YouTube channel where comments are not allowed. The bell notification is not allowed. So the thing I have come to realize is that maybe by mistake I entered a wrong line. We should not create kids content, and we should create adult content only, because it becomes very difficult to market. So like comments, bell notification, and these things are very common. So without these, how can a content creator survive? So I'm bringing a different point of view, but how can we circumvent or maybe live with these laws and still grow? Is my question.
I think very good point. I think we've touched upon this in the past, that what does that do for innovation for kids, right? Like if you have this thing, Nidhi actually runs a platform for kids. Nidhi, do you have any, thoughts on this?
So I'm very conscious that I don't run it like an edtech. So that has been one of our first principal calls, that this has to do with not tracking behavior. And definitely, so we did start off initially with looking at Google Analytics, and Saurabh is right when he spoke about some of these things have been set already thanks to how the platforms enabled some of the practices. And like I was saying earlier, now when we have to comply with regulations that are literally coming post facto, right? Then it becomes difficult to go back and correct some of the ways, and we don't even know whether what we were doing was right or wrong. And why does the law suddenly prevent us from doing something that was just, business as usual? So these are the negotiating challenges. These are the challenges that we have to negotiate as businesses, as individuals, as parents, and everybody. So it's not an easy path to kind of walk. And like Uttara was saying earlier, there has to be several steps and layers of learning before we arrive at an ecosystem where we recognize why some of the things that were okay earlier are now not okay. Right. And speaking about when you, Aparajita, when you pointed out about governments and, governments using children's data, this is something that we also do a lot. We do interact with governments, and unfortunately, with the entities that we have interacted so far, there has been not many instances of proactive accountability. So most of the entities say that why should we when there is no regulation that requires us to? But now that we have a regulation, how do we comply? So it's just a regulation that is forcing them to. Other than that, there is no other accountability processes. And of course, there are cultural layers to it. There are lots of social angles, and historically how we've been looking at privacy or children's privacy as such, which Sonali also pointed to. As such, children at home do not benefit with the kind of privacy norms that European homes do kind of follow. Now, India is also more of a market in many senses than, as a country. Many a times, that is also why privacy conversations take a back seat. And circling back to behavioral data and how platforms use them, I am really not even concerned about targeted advertising, and that's the only bit that gets highlighted in the Act. And which is why earlier I was talking about consent managers, because people will not have the nuance to understand what exactly these things mean. And behavioral targeting is often aimed at children to recruit them young. And all the marketers in the room will know what I'm talking about. Recruit them young is a strategy that people prioritize over child safety many a times. Let's bite the bullet and admit that, because the sooner we have audiences loyal to our app, the longer they'll last. So when we have a conflict of interest with business metrics driving us to recruit customers young, and then we have a law that says prioritize child safety, what are we going to go with? We'll always try to circumvent. So this is the kind of conflict and dilemma that I think we have to negotiate, and it will only evolve in the coming years as to how everybody is waiting for one big fish to take the big fall, and then perhaps, some standards will be set in place.
But even the third parties which are there, they are charging a lot. So one of the third parties is charging $15,000 just for certifying that we are COPA safe.
Yes.
So that is.
I think that is the risk with, having this certification mechanism, but I think it's the cost of doing business beyond a point. Prasanto, you had a question. I think I have time for 2 more questions. Maybe we can take the questions together and then we can answer. Yes. Okay, great.
Yeah, so 2 quick points. One is the legal foundation for this whole thing. It draws back, of course, to the 1872 and 1875 Contract Act and Majority Act. And it says that below 18, you're not competent to contract. And consent is a contract. But it doesn't, the Act actually doesn't say that consent is a prerequisite of a contract. And we try to push back on this point with MeitY. And somehow, their thinking was that no, for any law we ever make in the future, we are tied by 1872 and 1875, and they did not actually have the internet, not even 2G and stuff like that. So I don't know if you have a thought on this in terms of challenging this. And the other thing is, a more obvious thing in the social context. We have 800 million users of smartphones only, or maybe 750 million or whatever. Yeah. So what the whole process, the channel of that confirmation, etc., is all the same smartphone. Very often for 200 or 300 million of them, it's the kid actually accessing the smartphone. And whether you have a, an ephemeral and tokenized system or whatever, it's the kid who's going to say yes to that. So it's completely, it doesn't make any sense putting in a technological confirmation which goes through the same channel, which is that same smartphone. I don't know a way around that.
You had a question. Somebody had a question. Yes.
Hi. So I had another point of view. When you become an adult, you're responsible for the consequence of your action from the state and citizen point of view. So when you do something, you are by law responsible for all consequences thereof which you can foresee. Now, in terms of a parent and a child, it is not that the parent or the child is able to appreciate the harm, but the state is fixing responsibility of the harm to be caused to the child on the parent, saying, listen, it was done under your supervision, care, and you're responsible for the harm. So it's not so much of only protecting the child, but also protecting the state and the service provider, where the balance is that now you cannot, as the legal concept of volunteer non fit injuria, now that you've volunteered and consented, you can't complain of any injury, whatever can be reasonably foreseen.
So what you're saying is the purpose is transfer the liability from the child to the parent.
That's one way to look at it.
And then for verification, the purpose is to transfer the liability to the platform.
It's also to manage the risk and liability in a system, legal system.
Were there any questions or just comments? Okay, we're happy to take comments also, by the way. Can it be challenged?
The second one,
yeah. Okay.
Sorry, the second one was really that, is there, do we know of any technological thing way forward which will address the Indian context? The child is accessing the thing, probably for his parents' smartphone. Your channel of confirmation is that smartphone. The child is going to be the one who's going to say yes or no. Is it biometric, whatever? What are these ephemeral tokenized systems which are evolving?
Prashant, I don't know if you're aware, but DigiYatra was actually initially meant as a broader consent framework and not just.
Yeah.
So this is DigiYatra for everything. Sorry, Manasa had a comment.
There's really 2 questions, I think, Prashanto. One is, what are these ephemeral and tokenized lovely sounding systems that have emerged somewhere in the world? And I'm happy to kind of summarize that a little bit. And the second question is, in the Indian context, when a child shares the same device as their parent, how do you kind of get around this? Perhaps a yes or no form of verification is not the best in that situation. Perhaps provide your date of birth is also not the best approach. There is no, like Uttara mentioned a couple of times, there is no one silver bullet. There's no one answer. We need to think about how we can balance different conflicting principles of ensuring that the child has access to a productive digital platform. They have access to this platform going through the verification process in the manner that was intended, and so not using a proxy or circumventing it. And how do you balance this with principles of data minimization, with principles of purpose limitation, and keeping the best interests of the child in mind? There are a few, on the face of it, more invasive systems of age verification. For example, facial recognition technology. It's not foolproof. Uttara has spoken about it. It has kind of its own drawbacks. But if one were to pick this method of verification as the chosen method, then how do you build on top of it? How do you use this technology and build in privacy guardrails on it so that it's not, data that is collected, for instance, is not retained in perpetuity? There are a host of other issues with facial recognition technology, but I'll kind of jump to your second question in the interest of time. The ephemeral and tokenized system that I was talking about is actually not something that's in effect right now. It's something that's being considered by the CNIL in France. So they're working with a think tank slash privacy expert, cryptography expert, to devise a system where the age verification question is actually a challenge that's posed to the minor. And it's a cryptographic question and answer kind of challenge. There is a certain amount of friction, but if it's answered correctly, then the assumption is that an individual over the age of majority would have only known the answer to this kind of question. For the life of me, I couldn't find an example of what this challenge would be, but that's the idea. It's also ephemeral and tokenized, meaning that only a hash is shared between the third-party verifier and the platform to which the minor seeks access, and it's also deleted almost immediately. So in those two avenues, it's privacy kind of protected, but I'll pause there.
Can I make one additional point, very short? I think that the public policy objective of the parental consent, Section 9, is to keep children's data private, right? That's the objective. We know now that verification mechanisms are not foolproof, okay? And I'd go to say that you cannot think about it as the only way to ensure safety. There are a million other things to do. So you got to think about it in a cohesive way where safety by design, privacy by design principles, content moderation, plus verification are a basket of solutions. So I would say.
So we have two very quick questions and very quick answers, please. We're bang running out of time. One is a question that we got on Zoom, which I really liked, which is, if a child who has given consent without parental permission and is now in conflict with law, will the parent be held liable for that? No answers?
Look, I'm not a lawyer.
Okay,
so I
so
yes, of course. Yes, of course.
Then what's the point of consent? What's the point of parental
Exactly.
consent? Because the parent's going to be liable anyway.
Exactly. Absolutely. That's because they're minors. No, the liability is of the parent. And
Okay,
that's the challenge that we're all struggling with.
So we haven't solved a problem that didn't need solving. Okay. Quick question.
Yeah, I will try and be quick. There's been recently, like 4 or 5 years ago, there was a lot of hue and cry about the POXO Act and as to how it essentially made any children just this subject of the state. I know that internet has changed. It's not the same like 10 years ago when I was a child. But sorry, just 1 second. The question is there a need for a tiered approach? Is this going to lead to a complete surveillance state on the child's access to the internet? Like, you have hardware OS models that there's a user that is designated. Is this a surveillance state? B, what time are we competent to sort of codify that there are tiers of children even so? That, 16 to 18 in an urban center has schooling is going to be treated differently to below 12 or below 13.
Can I answer it?
We've answered some of this already. By the
Yes,
way.
we
So
have.
whatever's left.
I just want to take a quick minute. I think if this law is actually implemented without any exemptions or any of the discussion that we just had, we will become a surveillance state, not for children, but all of us as well. Because we will have to first verify who we are, what is our age. And then if by chance we are children, then the state will also verify whether my parent is giving consent or not. And when it comes to children, this is very problematic because even your thoughts sometimes are ephemeral. We at YLAC work with a lot of young people, and in the between the age of 13 to 18, they are sometimes exploring their sexuality. They are a little confused about where they stand. So they will have all these conversations about, for example, I'm a bisexual, or maybe I want to change my gender or whatever. Imagine all of that gets linked to a verified identity which somebody can actually go back to. I think age verification is not just about children, it's about all of us at this point.
Nidhi has her hand up, I think.
Just a single line to kind of conclude that. We also need to kind of look back at other things that currently children are not allowed to do for the same reason that their brains are still developing. They're not allowed to drive, operate heavy machinery, or take up employment. So there are precedents for us to look back at, and these are all necessary things for an adult to kind of engage in. But for the same reasons that children are not allowed to do that, we need to also set those graded rules when it comes to digital technologies, which are highly potent. That's it.
Great. Thank you so much, everyone. I guess there's a break for chai, coffee.
Unfortunately, the tea is not ready.
Oh.
So for all of us, so we'll go on with the next session, and after that, you can enjoy your.
Great. Thank you so much.
Thank you. Thank you very much.
Thank you so much for that, Aprajita. Up next, we have a roundtable with the people who've been implementing privacy laws across top global companies and Indian companies as well. We have our Chief Privacy Officers Roundtable. Moderating this is Rahul Narayan from Chandiok and Mahajan. And joining us today, we have Jagannath PV from LTI Mindtree and Bharat Saraf from PhonePe. And joining us online, we have Vasudha Gupta from Unlimit. Thank you everyone for joining us, and look forward to hearing it.
Good evening, everyone. I'm a little saddened that the tea and coffee is not ready yet, because I think that always helps in keeping people awake. I have recently taught a course a couple of days ago, and what I learned from the professor who was teaching the course with me is that one interesting way to wake people up is to make them put their hands up and shake them. I don't think we need to do that because we've had some really interesting sessions, and no pressure, guys, but I'm sure we'll live up to the earlier sessions and make it as interesting as possible. So please welcome everyone to this Privacy Officers Roundtable. We are going to discuss with eminent people in this field what it means to be a privacy officer and what it means to implement these policies, and the impact of the new DPDP Act on this, etc., etc. So before going any further and boring you with everybody, let me introduce our panelists. I'm going to start with Vasudha, who is on the screen. Vasudha, are you here?
Yeah, can you hear me?
Yeah. It's nice to see you. Vasudha is the Global Data Protection Manager for Unlimit. She is responsible for developing, documenting, and maintaining the Unlimit Data Protection Program. She has over 8 years experience in technology-related laws. Previously, she worked as Privacy Counsel for PayU India and at EY, where she developed her skills in privacy laws, risk-based management, and auditing. Vasudha is a certified privacy professional with CIPPE and holds a law degree from National Law University, Jodhpur. Then we have Dr. Bharat, who we are very happy to have him over here. Dr. Saraf is a director and heads privacy at PhonePe. He was the first hire to lead and build an independent privacy function for the group. With 15+ years of experience, he has previously helped Indian MNCs set up their global privacy compliance programs. He is a fellow of the IAPP with multiple privacy certifications. Dr. Saraf is also a qualified Indian attorney and holds a PhD in law from Monash University, Australia, specializing in e-commerce and privacy laws. And last but not the least, we have Mr. Jagannath PV, who is the Global Data Privacy Officer at LMI Mindtree. And just one second, I'm going to have sorry, just one second. Jagan comes with 20 plus years of industry experience. He graduated from RV College of Engineering and has an EGMP from IIM Bangalore. Jagan is currently the global head of data privacy at LMI Mindtree, a $4+ billion organization. He has implemented the data privacy framework from scratch, covering 37 jurisdictions, and advises on others on various aspects and perspectives of data privacy. Jagan has played several leadership roles across his career, from heading data privacy, delivery management, heading alliances, heading transition, etc., etc. Anyway, I look forward to a really interesting discussion with all of you guys. And let me start with Jaganji. As you might have noticed if you were paying attention, which I'm sure all of you were, one person is not like the others. Jaganji is not a lawyer, but is actually an engineer who has got into this by practice. So my first question is related to that, Jaganji. What do you feel do you feel unusual being a non-lawyer in this in a field like privacy? And how do you think it impacts your thinking and your functioning coming from an engineering background?
Right. Thank you for the introduction. It's a pleasure interacting with all of you. Well, firstly, I learned this from y'all, and to quote that whatever I say is on my personal experience and not on behalf of my company. Well, until I got into this role, I didn't know it was filled with lawyers. So that's how easy it was for me to get in. So I just took it up as a challenge and got in. Of course, I enjoyed privacy. And one of the first few people who I met in the data privacy role was Bharat. While it's been 2017 is when we started the journey, this is the first time I'm meeting him in person, though we have worked with each other for almost 2 years. Yeah. So how did I transition? Of course, I took it up as a challenge because of GDPR. I think that was an excellent opportunity that many in people in the industry got an insight into data privacy. Well, from there, it's been no looking back on data privacy. Well, like I said, I never thought it was meant for lawyers. I thought it was meant for everybody. And today I can simply vouch that you all should learn technology. Majority of you all are lawyers. So with the experience that I've got in this role, I would really vouch that at least you should get a view of what technology is, so that you will not unnecessarily get taken for a ride. Right? That's the first thing, because especially in these roles, they're treated as compliance roles, they're treated as regulatory roles. When you go back to your ecosystem and tell them that this is what you need to do, and then when they respond to you with an answer, you should be able to correlate that answer, right? You should be able to evaluate that answer. So unless you understand technology, you will not be able to evaluate that answer. I think that's a significant learning for me. Well, of course, you may counter it saying that you need to learn law. Yes, that is what I did, not law, but the regulations. So the way I took it up was read about it, understand it, and being from the business side, we did have a flavor of law, right? Because you write contracts, you deliberate on or you negotiate contracts and so on and so forth. So we did have some visibility to law. But nevertheless, data privacy is a completely different field. And today, if you ask me, I think it's an excellent collaborative platform for technologists as well as lawyers in the field. And if you ask me what is the right combination of a data privacy team, it is actually a combination of lawyers and technologists, right? Only then you will be able to really put forward what you want and ensure it gets implemented in the way you want it to get implemented.
I think that's actually a very, very, very nicely put. I think the actual truth is that unlike many other lawyers, technologists treat him with respect because he's one of them. Otherwise, there is a mutual fear and admiration between lawyers and technologists, and particularly in the privacy field. In fact, I used to joke about this about 10, 12 years back, that all lawyers should write a book called Privacy for Techies, and all techies should write a book, Technology for Lawyers. And the fact that you are able to combine the two fields actually is really interesting. Coming now to Bharat. Bharat, you have done a PhD, which makes you extremely well qualified, and of course, you've done a lot of qualifications in the privacy field itself. So, when you examine this field today, do you think that when you look at privacy itself as a concept, do you look at privacy as part of a design in industry, or do you look at privacy as a compliance issue?
Thanks, Rahul. Good evening, everyone. It's a pleasure to be here. So to your question, Rahul, I think when I started out way back, just out of law college, and I was looking at areas to explore, expertise to build in way back 2008, 2009, and that is where I landed into privacy. At that stage, privacy, for sure, in Australia, where I was studying for my PhD at Monash University, Australia, there it was a much more evolved field. It was looked at more from a compliance standpoint. There were a lot of research papers, a lot of universities, a lot of data protection authorities being set up, and commissionerates being constituted to release guidelines, have a lot of discourse around privacy. So when I started out to read for my PhD, I think GDPR was just evolving as a concept in the European Union. 2012, I think the European Data Protection Board and its former body, they started to deliberate around the concept of consent. And the premise for GDPR coming into play was around consent. Because if you look at the 1995 directive for privacy, it was basically focusing on consent. And what the authorities in 2012, or by that time, they had realized was consent is a misplaced normer. Because in most of the scenarios, and we have heard our panelists before, I think consent is valid only if there is equal negotiating power. And when we were, there were certain questions around take it or leave it, right? And that is where consent comes or becomes a problem. And GDPR came into being for that simple reason that the Europeans wanted to do away with consent and pass on the entire buck back to the data fiduciary or the data controllers, as they call it. They wanted the data controllers to take back control and ensure that the data that they are collecting, they are accountable for that. So from that standpoint, when I was looking at, or I was reading and researching around privacy as a concept, it was more from a compliance standpoint. When I came back to India, I think it was, of course, being debated. Of course, it was just at very initial stages where I could see sales and marketing teams, individuals from these teams being privacy officers or handling privacy at organizations. And when this concept of privacy started actually as a discourse, and it started being coming to the fore at larger forums, larger compliance discussions, I think that is where the entire narrative around privacy changed. And of course, the big push was the GDPR coming into play in 2018, where I think Indian MNCs having offshore offices suddenly realized, hey, we need to be privacy compliant. And what is that we need to comply with? How do we go about compliance? And that is where I think privacy in India took a major shift, a major change, where companies, MNCs started to realize it started to become a board agenda with respect to the risks that were identified in the GDPR. How compliant are we? Are we going to be fined for non-compliance with privacy? So when I see at that evolution, I see more of it as a compliance. But especially now that the data protection bill has come about in India, I am seeing it more as a DNA in every organization that they have to protect customer data, employee data, or for that matter, any data that they are processing about an individual. So if you look at it, Rahul, I would say that it has evolved basis the global penetration of privacy in the EU, in Australia, and other jurisdictions. And especially from an Indian standpoint, I think it is slowly moving from compliance to being the DNA of an organization, because it is going to be a differentiator for every business to be privacy compliant and say that we are the leaders in privacy. That is how I see it at the moment.
That's actually a very good answer, and I have lots of clues for the next question I'm going to ask you. But before I do that, and before I come to Vasudha, I'm going to come back to Jagan and his thoughts about this, because I understand he's done a lot of work on privacy as design. So could you tell us, could you also try to answer this question? Do you see privacy as design as a concept? Or do you also see it, particularly because of your background and how you've come into this field, privacy as mostly a regulatory issue?
See, I would honestly strongly vouch for privacy by design as not a concept, but like Bharat said, it should be in your DNA. Right? And that's one of the best ways to adopt data privacy and ensure that you adhere to the law. Right? The minute you start looking at it as compliance, it becomes a tick in the checkbox. Right? And that should not be the approach. At the end of the day, the privacy by design, I mean, I'm sure many of you would have heard the principles of privacy, the 7 foundational principles of privacy by design, and then the 5 principles of data privacy laws. That is what evolves around any data processing. So we invest a lot on privacy by design, looking at it from 3 different perspectives. One is from a business perspective. 2 is operationalizing privacy by design. And 3 is enabling privacy by design with technology. So what does that mean? So if an organization adopts privacy by design, you are adhering to privacy laws as well as taking measures before something happens. Okay, there are 2 concepts to privacy by design: privacy by default and design. That's what it's called. So when as an example, when you roll out an application, there are certain measures that should have been there by default. Okay, so it could be a password protection, right? And a strong password protection that should be by default. So there are certain aspects that should come in by design. So what are those aspects? Consent management, right? Granular consent management. I'm a fairly significant advocate for granular consent management rather than taking consent as a holistic view. So those should come in by design, and it can go on and on. And then from a technology perspective, you bring in the aspects of encryption, you bring in the aspects of pseudonymization, anonymization, you bring the aspects of privacy enhancing technologies, like building in cookie compliance frameworks, building in consent management frameworks, building in any design frameworks for applications, for operations, and operationalizing these with a very strong data privacy office, with a strong structure on DSR management, data subject rights, which are data principal rights management, and so on and so forth. It's a big topic by itself. So if organizations adopt privacy by design from the start, or even as of today, you will be a lot more mature, or will elevate towards a mature privacy focus, privacy centric organization, and your privacy posture will become much more stronger, right? And that's the reason I vouch for privacy by design. And in wherever I've played my role of data privacy, that's the first thing that I do. So it is across the organization that needs to adopt privacy by design. And I just want to extend this the answer, if you don't mind, right? So I just want to extend saying that privacy function itself should not be seen as a regulatory function, or sorry, a compliance function. It should be a facilitator. It should be a collaborative function. Okay, only then people will appreciate what you're trying to tell and adopt to what you're trying to vouch. Okay, the minute you say it's a compliance function, they'll take 2 steps back and say you're always trying to put roadblocks to what I'm trying to do. Classic case could be sales and marketing. They always want more and more and more data, right? But how they get their data, they're really not interested, because they want to reach out to as many people as possible. Similarly, finance function, right? Or talent acquisition function in terms of recruitment, employment, so on. So everybody wants so much of data. So the minute data privacy comes into perspective, they start thinking that, oh, this guy is not allowing us to do so many things that we were doing. But you change that game, and then you tell them, hey, you know what, this is not the way to do it. You should probably approach this in a different way by adopting these principles. While taking care of privacy, you are actually addressing so many other aspects of your business need. So you must be seen as a business facilitator. You must be collaborating with your businesses to be able to build a proper privacy framework and evolve into a much more better postured organization from a data privacy perspective. So again, just re-emphasizing privacy by design, I am a big advocate of it, should be in your DNA.
Thank you again. Many clues to take this discussion further, but I would like to come to Vasudha now. Vasudha, what is the role of a data privacy officer? If you could tell our audience, what is that you do on a day-to-day basis? And what is it that you began by doing on day one of the organization? And how would that be different from, say, day 100?
Thanks, Rahul, for the question. I think it's a very good question. And just thanks to Dr. Saraf and Jagan sir for bringing in the basis for what we do on day 0 and on day 100 as well. So I think the first step is to look at data protection, as Jagan sir mentioned, more like a design approach and a collaborative approach rather than a compliance approach. And I think building on that, the first thing that one could do is to develop a privacy program, right? It's not necessary that if you're a global company and that's when only you need a global program. Even if you are just set up in India, right, to comply with any data protection law, it's very important that you have a program in place, you have a set of activities, processes, and policies in place, which then support you to bring in things like privacy by design, regular trainings for the employees, and those are the things that then the program is built on, right? And as for day 0 activities, I think to start off with something very simple, I think it's stakeholder engagement, right? If I don't know and my team doesn't know me, and if they don't know what a DPO is, who that person is, they are not going to be able to bring in things like privacy by design. They need to be able to reach out to me. They need to know that the DPO function is ready to support them. And more than that, we need to understand what they are doing in their daily jobs. For example, the marketing function, right? You have your emails going out as a subscription, etc. We need to understand what they are doing, what data then they are collecting, how they are collecting, where it's stored, whether consent is taken or not. So that can only be built when you have a good stakeholder engagement based approach as a DPO, instead of just saying that, no, the law is here, this is to be done, please do it from tomorrow. That does not work, and that's not what a DPO's role is, right? Secondly, I think the most important function that we have to undertake is knowing the data, where it is in the system, how it is being processed, where it is being stored. Without knowing where my data is sitting in the system, I cannot put any control or process or policy and ensure its implementation, right? And I think there are a lot of vendors coming in and automation systems coming in which help with data discovery, and that's one way to go for a larger organization. Another way to go is to actually build on stakeholder engagement and have those sort of meetings and say hello to your function and say, okay, what are you doing today, right? What is it that you do every day? Where do you process the data? How do you take it in? And start to map that data ahead. And I think the third most important thing for, I think, the audience today is to look at your user facing documentation. Your how you're taking the consent, what your notices are saying, how they are built, whether they are concise. I think in my experience, I've seen a lot of notices being extremely lengthy with a lot of legalese. I think our day-to-day job should be to simplify those for the users, for anybody who's coming. Us as a company should be able to concise what we do in a way that people reading that should be able to get it, because it's not just the users who are reading it. Any vendor, any merchant that we are speaking to is looking at the privacy notice. So I think couple of these activities would really go a long way in building support for a program on day 0. I think day 100 is full compliance level, to be honest, but that's not something that's achievable in 100 days, even with any law. And I think from a lot of companies, even till now, GDPR implementation does take time. These things do take time. And of course, maturity is another topic that we can explore probably today. But yeah, for now, day 0 activities are these.
Coming to that, adding a little bit to that, Vasudha, and asking a further question. You deal with compliance with a lot of jurisdictions. how do you manage to create policies that look at the law, that take into account all the laws? Is there a way in which you go about it, in which you think it's a smart way to ensure compliance generally, or is it you have a general rule which you start with and then build it up from there?
So Rahul, that's a very good question, and I think there I would want to start with how a global program works, right? When you're working in more than one jurisdiction, the global program works from a perspective that you pick up. So, for example, our company is mainly centered in Europe, so GDPR obviously becomes applicable, right? It's the first law that we comply with, and then from there you start to begin a baseline, right? You set up a framework. A framework would basically then allow me to analyze all these 12 countries, their laws, what is applicable to me in which country, where do I need to take a local deviation, where do I need to follow, or a principle coming from GDPR can be followed. So let me put it this way. When I'm looking at 12 countries, I need a framework, I need a standardized framework, right? And that framework can either be GDPR, it could be something like ISO 27701, it could be a ICO accountability framework, it could be either of those. But what I need to create is a base, and then from there we go on to map any local deviations. For example, let's pick up India. India has this data localization circular, right, from RBI, and then we look at it as a business risk, and that's a separate compliance that needs to be done, and that's done globally for all our jurisdictions. And it's a tough job to manage so many laws, notices, and it's a hard job. But what we try to do is actually rely on a customized framework for our organization, so that we are then able to suit the needs of the business as well, right? Because there are some goals, there are some expansion projects, all of those need to be taken into account as well. I hope that answers your question.
That does, actually, and thank you. Coming now back to Bharat. Bharat, do you think that sometimes your compatriots in the other parts of your organization think of you as the villain, putting a stop to all interesting, fascinating new things because this is not data compliant? If so, what is a good way for you to ensure that you're not the villain who puts a stop to everything, but a person who helps in facilitating the creation of a program which satisfies the law and which satisfies the correct principles behind the law?
Yeah, so I think a simple and a straight answer to that would be collaboration. And I think Vasudha brought up that point very effectively. So I think collaborating with all the stakeholders, and privacy is such a central core function of an organization that you need to be aware of all the stakeholders, the key stakeholders who are decision makers on pieces where there is data processing that is going to happen. So whether that be a sales and marketing team, an engineering team, a business team, a product team. So you all need to have that collaboration with each of these particular team members. That is the key to having privacy in the DNA of an organization. Now, having said that, I think if I could come back to the answer of 0 to 100 days, right? And how collaboration has helped me at PhonePe from an experience standpoint. If I look at how I've gone about building the entire program and building the entire culture around privacy at PhonePe. So day 0, I think I had to actually sit down with each and every stakeholder just to explain to them what is personal information. What is the difference between personal information and sensitive personal information, which was under the SPDI? So there were random questions like, does email constitute personal information? Is mobile number and personal information? Because those are random 10 digits. So day 0 starts with that. Once you want to get started to build out a privacy program, I think these are the sort of questions which are very natural to come from your stakeholders, because they would like to understand each and every aspect of what is that privacy entails. Having said that, I think the collaboration post that was the key in helping me build that relationship with each of those stakeholders, trying to get into their thinking process. For example, if there's a product manager who is thinking about building a particular product, giving him insights as to what sort of data is he trying to collect, How is he trying to protect that data? How is he trying to share that data either internally with the group entities or externally with third parties? What is the mechanism to retain that data or delete that data? So those insights are very much required in the collaborative process that you work back with every particular team, with every particular manager. Apart from that, I think trainings play a very crucial role. And by that, I mean not a org-wide training, which is just to meet a privacy compliance tick mark. It is more about having focused group trainings, say for a particular product that is being discussed or that is being launched or that is being designed by the various teams. So sitting down with them, helping them understand where are the privacy implications, what is that you all need to think about, where is the law going to come into play, and hey, going to say from a principal standpoint, you all cannot do this, or you all can do this and we can be an enabler and try to figure out solutions. So being collaborative and then helping them figure out solutions is what has made my journey at PhonePe much more simpler in building out and carving out the entire privacy compliance program. And at day 100, I wouldn't say day 100 because I don't know how many days does 3 years constitute at this stage. Yeah.
1001 nights, like the Arabian Nights.
Absolutely. Yeah. So now I can confidently say that any product manager thinking about a product first thinks about privacy. That is the sea change that we have brought about as part of our DNA, as part of our thinking process, and as part of privacy by design, which Jagan had just previously mentioned about. Because now every stakeholder, every team thinking about building something for the consumer at large, thinks about how is privacy going to be impacted by this and what are the ways in which we can build this particular product, build this particular data processing in a more compliant and a friendly manner so that the user is having transparency around what we are going to do with their data and how we are going to protect the data for the different consumers that we have across the different businesses that PhonePe runs.
So, I mean, I absolutely love your answer because it's related to a question that I was going to ask you, but you've already answered part of it. So I'll put this to both Jagan and to Vasudha. Let's take a hypothetical situation. Let's say you join as the chief privacy officer of a finance company. Let's call it B Finance, which has been spamming people quite a lot in India. And we don't know the sources of those numbers, and they had to clean up their act. And, this is the company that recently said that they'll put a do not call registry of their own where people can unlist their numbers, and all the data that they've collected is, or much of the data that they would have collected is without consent. Day one, what would you do when you're dealing with perhaps a vast amount of data sets that are being operationalized and the sources of that data is not even known? And the entire business model of that company depends heavily on that spamming that happens.
I'll let Vasudha go first. I have an answer, but I want.
I think building on what I said earlier, Nikhil, I think the answer is I'll just get a vendor to understand where the data is coming, going. If they're going to spam, I think that's the first thing they need to invest in, right? If you are going to handle vast amounts of data, you need a system to understand where the data is getting plugged in, where it is getting stored, and how it's moving out, right? Because when you have that much amount of data and you do not have any controls on day zero, you are running into a breach situation and you wouldn't know where to look for, right? So I think building a data governance approach and starting with the data discovery way forward would be my approach here. But I'll let Jagan sir then also jump in here.
First thing I'll do is pick up one of these.
Good answer.
So, yeah, I think I agree with what Vasudha was saying. Well, you said it's a spam. I mean, spamming. I mean, they've been spamming all over the place. Well, fortunately, I hope they're an Indian company, which in your mind if they were in Europe, they would have been shut by now, right? Or they would have been slapped several fines. Yeah, I think it's very important for an organization to know what are the collection points of the data, right? If you do not know your collection points, you will not know where it's even, how it's even flowing and what are the lawful basis of processing. Okay, so I would, if I were the CPO of that particular company, first thing is I would understand what the lawful base they're using, right? For so much, they've already collected tons of data, right? What is the lawful base they have used to collect that data? Of course, I mean, we already know that there's no lawful base by the example that you've said. I mean, they've been spamming. So I would work on adopting a lawful base for data processing. Okay. So once that is done, then I would want to find out how much data I have about myself, because they're already spamming me. You can't just go and stop everything, right? So I want to understand how much data do they have? I mean, which jurisdictions they have, right? Focus on those jurisdictions. There are certain jurisdictions which don't need immediate priority because like for example, India, there is no really enforcement of spamming, right? So I wouldn't say I would deprioritize that jurisdiction, but I would put it in in another bucket. Whereas I would focus more on Europe, Canada, Australia. US, again, I would put it into the India bucket. I mean, if you look, you have to kind of prioritize and then start looking at, have they got any consent at all, right? Because marketing data predominantly works on consent, right? If you are procuring data from other sources, you still need to get consent, right?
Can I add another layer of complexity?
Are you talking about data scraping?
Well, no, I'm not talking.
Okay.
I'm talking about outsourcing of marketing, because that's the other layer, right? There are companies who say that we're not responsible for this because it's been done by a company that we've outsourced to. So how does the data protection bill address that situation for one? And how would you go about cleaning that function?
That's a wonderful question. I think that's a very good question. I mean, you're making me jump to that before answering the first one, because
go ahead.
I think that's a very, very apt question, because from a DPDPA perspective, I think your question was more from a DPDPA perspective. It is very, very important for data fiduciaries to look into that, because there is no obligations on data processors in DPDPA, right? Everything falls on the fiduciary. That means to say, if somebody is messing up on your behalf, you are going to be held accountable. So your contracts needs to be very, very strongly written, right? In line with the law. Okay. Now coming to the first part, combining both the first and the second part, let's say if some other company is doing it on my behalf, I want to ensure that they are doing it lawfully. Okay. And I want to also ask them, how have they acquired the data? Okay. If you have acquired it via consent, do you have a audit trail of that consent? Tomorrow, if the data protection board or any data protection authority across the globe comes and asks you to prove, you need to have that audit trail of that consent, right? And then when was the consent taken, and so on and so forth. When was the notice provided? Is there a withdrawal of consent provision provided to these individuals? Most likely no, from the first example that you gave, because they've been having that data forever, right? So I think these are the aspects that you need to take. So jumping back to the first question, first lawful base, I would want to understand, then look at my data. What kind of data do they have? Prioritize. You can't attend everything at one shot. Prioritize, then start targeting each jurisdiction level data. There is no harm in sending another, or I would want to implement the opt-out option first, right? Which I'm assuming is not there. Otherwise, by now, at least many would have opted out. Okay, implement the opt-out option, and then revalidate your consent mechanism. What kind of consent you're going to take? Is it going to be granular consent? I'm a big advocate of granular consent, because for two reasons. One is you are allowing the data principal, data subject know why you are taking consent, right? Two is, if they are opting out of consent, you are not. If you do not take granular consent, you need to opt out of everything, right? Instead, if you provide a granular consent mode, you can opt out. If somebody wants to opt out of newspaper subscription, newsletter subscription, they can do that, but still can be contacted, or vice versa. I mean, they don't want to attend your events, they can opt out of the events, but still want to get your newsletters because they're interesting. So get into that model, and then of course sensitize your team, the marketing team, on what the law is. I think that's a very important aspect. you should make it as simple as possible, right? At the same time, you can't just say the law says this. You have to articulate the law in such a way that they understand what the law says and what are the implications for the company, right, on what the law says. Okay, now I just want to add one point: data scraping. That's such a big thing in today's scenario, right? I'm sure as lawyers, you must have heard about the Clearview AI case, right? So what they did was they were scraping data because it was freely available. That is pictures of people, right? And they've built a wonderful algorithm or a product which can detect a person's face and pretty much an FTR technology, facial recognition technology. Okay, and it's a great product. But then almost some 7 jurisdictions across the globe now have fined them. They've kind of got out of it with ICO at this point in time. I mean, they've only given them a levy, but what the jurisdictions say is, if data is freely available, like yours and my data on Facebook or Instagram is freely available for others to see, but not to use, right? It's freely available for you to see it, but not to use it. So this Clearview AI used to bring all that data and then start using that data. That's how they've got penalized. Now, my fear is DPDPA allows you to do that. That is my biggest fear. Publicly available data or freely available data, you can use it. So the same thing is going to happen here. I mean, we have vouched our dissent on that particular clause, but it's not a good thing in DPDPA. Okay, so I know I've taken your question in a different direction as well, but I thought it will help people understand when you come across contracts which are actually looking at scraping data. That's the first thing you need to ask: which jurisdiction? Because there are certain jurisdictions that do not allow scraping of data. There are certain jurisdictions that allow you to scrape only those sites that allow you to scrape. Right? There are sites that allow you to scrape. There are sites that very clearly say don't scrape. Okay. There are, now coming back to marketing example, there are platforms that allow you to do marketing. Okay. For example, something like Zoom Info, right? So they also do a lot of scraping. Okay. So such platforms, I'm not talking about Zoom Info in particular, they do a lot of scraping and they do different types of scraping. They may have algorithms which may say, if you attend our webinar, right, you have a notice that is provided to you. Not many of us read that notice, right? We say consent. So they can use your data for that, right? At the same time, if somebody invites you for a webinar, they can use that data for that. And another example is they can go and scrape the internet. But these tools also need to understand, while scraping is allowed, right, they should provide an option to fiduciaries to use scraped versus non-scraped data. That is, as a DPO, I ask my marketing teams this. Okay, if you are procuring data, if you are collaborating with another platform which allows you to collaborate in such a scenario to host a webinar and all that, are they using scraped data? Is there a provision in that platform for you to opt out of scraped data? Because at the end of the day, you become, in European terminologies, you become joint controllers or independent controllers when you start acquiring that data, right? Here, fiduciaries. So when you become a data controller, you need to ensure that that scraped data is consented. So you have to go and take reconsent of that for that scraped data. So I'd rather not use that scraped data. I'd rather use data where I have control of and I know has been lawfully gotten. Right. Sorry, I've really extended that answer, but yeah.
Yeah. And Nikhil, I think just to add as an answer to your question as well, and what Jagan mentioned, I think this is going to be a BAU sort of a discussion in all organizations for sure at the moment, because
sorry, what's BAU?
Business as usual conversations. Sorry for using the abbreviation. Because in the organizations, I think people are not yet aware as to the sources from which they have collected historical data. Although the Data Protection Act allows rollover of historical data with an opt-out, but I think the sources of that, as Jagan was rightly mentioning, is not yet very clear among the organizations. One, was there explicit consent when the data was collected? What sort of processing was being carried out and will be carried out? Third, will you actually require this data? Fourth, have you past the retention schedule for that particular data. So these are the sort of conversations for role of humongous amounts of data that currently organizations hold. And as a DPO of an organization, I am seeing that I think there are very few conversations that are currently happening on the process to roll over historical data and how we have to go about it. But I think some of the practical steps that both Vasudha and Jagan mentioned, including starting from data discovery, having those discussions with those stakeholders, understanding where and what was the source of data and whether it can actually roll over, reinitiating the consent process with the data subjects. I think this is going to be a humongous exercise for any organization who has customers, especially in B2C context. I think challenges such as, for example, if we have millions of customers from whom we have collected data and we are processing that data, if we have to send them an opt-out option, where do we send that to? Do we have their verified email address? No. If we are collecting their email address, is that an additional collection which is allowed? I mean, the rules have to clarify all of that. And this is where I think when GDPR came into play in 2018, I think these are the challenges that especially sales and marketing sort of organizations faced. And some had to shut shop because they really did not know what the source of that data was. And I think, and that is also going to be a challenge with our Data Protection Act. I hope the rules will clarify all of these things, not at a granular level, but at least at a high level, we get some sort of a guidance as to how we go about historical data and revalidating the historical data so that we can process it further.
So basically what you're saying is purane paap dhone ke liye, you have to take consent all over again. If you were to, I mean,
it's an opt-out that you have to give.
Opt-out. That's what I'm saying.
With
to
a notice.
Clean all your old sins. And this is a very, very quick question to all three of you before we get on to more interesting matters, is that if you were to design yourself a provision in the act to deal with this issue of old sins, so to speak, what would you do? Just in 2 or 3 sentences, please. Can we start with Bharat, then go on to Jaganji and then Vasudha? How would you solve this problem if not this way?
Yeah, I think the provision that is there in the DPDP Act is a good provision of giving an opt-out. But I think what the clarification that is required is, one, how do we contact the data principals from whom we have collected the data previously? Can we go ahead and collect additional forms of maybe data elements like email address or mobile numbers to contact them? Second, more importantly, if the data principal does not respond, can we continue to use and process that data unless they opt out? I think that is very critical, because I think that will help us solve and understand whether historical data that we have collected about our users can roll over and can be processed in an ongoing manner or not.
I think very good points that Bharat articulated. I just want to add to that. Now, I'd like to bring in the data retention aspect here. There are two ways of looking at it. One is if it's only a newsletter publishing, right, that you're going to send, you can't really validate if that data subject or data principal is active or not. Otherwise, I would rather apply a data retention principle of saying, if somebody has not, you have not, or they have not interacted with you for more than 2 years, that means they're not interested in you, right, in interacting with you. 2 or 3, whatever the timeline your organization feels. You don't keep it perpetual, but at the end of the day, if somebody is not interacted with you for 3 years, that means they're not really interested in hearing from you. So delete all that old data. It'll reduce so much of data that you have, which you're actually wasting time on by sending emails to, right? So that's one way of looking at it.
In fact, it's a question I asked in the first panel as well, that should the rules incorporate an aspect of deprecating consent?
Yeah, I heard that. Yeah. In fact, I wanted to pick up the mic on that. So, yeah, see, consent, no regulation really has called out the life of consent, right? I think when I was interacting with Bharat, when he was my advisor in his EY days, we actually debated this aspect. How long should we keep consent? There's no answer. I mean, I think you have to come up with some advice from law firms or things of that kind. So to to again go back to your question, you have to decide within your organization how long do you need to keep that, right? That's a data retention policy that you put together. Okay. So based on that, I think that's a more practical way to apply data retention. Okay, rather than trying to do something very differently, because it's how long you want to use that, right? Use that data. Is it going to be useful for you 2 years later? If it's going to be useful for you 2 years later, you might as well use that data and give the option to opt out. If it's not going to be useful for you, I think one of the examples that you were quoting was if I buy something and I don't go back and buy, right? And
I was talking about Android. Android removes permissions
correct,
over a period of time
Android.
if you don't use it.
Correct.
If you don't use it.
So if they don't use it, and if you think it doesn't make sense for the other person to keep it, you'd rather delete it. Okay. A parallel example I would rather give is job applicants, right? Now, how long are you going to keep a resume? Okay, there is no point in having a resume for more than a year, because a person would have learned something else and they would have updated their resume by the last 1 year, right? So I'd rather say, instead of keeping it for 4 or 5 years and going after an old resume, you'd rather delete it in 1 year. So I would apply that practical principle of data deletion on your question as well. That will make it easy for companies as well as the data subjects to understand what you're doing as a company.
That's again a very good point. Vasudha, do you have any thoughts on this?
Just one thought here, just combining what Dr. Saraf and Jagan sir are saying here. I think one approach could be to look at a consent preference center. I think that's something that's really picking up, and it's used in a way that it's easier to reach out to users, right? For example, here we are talking about marketing consents, and as Jagan sir correctly mentioned that, you know, the legal basis here would definitely be consent, right? So then you have an issue of verification. How do you verify that the person who's come to you is actually the person who they are claiming to be, and then they want to opt out, right? So one way to look at it is to build a preference center, right? Because your business is dependent on that data sitting in your system. You need to find a way to automate that. You need to have a place for people to log in. Now, as Dr. Saraf mentioned that, you know, it could either be your email, it could either be your phone number that we have, right? We don't want to collect more data. You bring in a center where a person can log in, and then they can be verified with that through an OTP or any other mechanism, and then they could choose to, you know, opt out of various things that services that you're providing them. So that's another way to handle this situation. Or I would look at it to manage it in a way that that keeps the business going, right? So that's my 2 cents on this one.
Okay, I think it's about 5:20, so I'm just going to do a quick one more question before we open it to the audience. And since this panel seems to be constantly shifting between the sublime and the practical, we'll go back a little slightly sublime, but basically practical question. If the Data Protection Authority were to grant you 3 wishes in the regulations in your field, what would those 3 be to make your business life easier? 3 wishes, like a genie. What would they be? Your 3 wishes.
Oh, that's a tough one, I guess.
What do you want?
I would rather turn this question around as to what would be 3 genie wishes from the board of my organization. If I may answer with that particular question.
That would be very interesting. Please go ahead.
So clearly, I think independence of the privacy function, clearly understanding that security and privacy are 2 different facets and 2 different functions that need to operate independently and separately. Of course, there will be overlaps, but they have to be independent. Second, I think would be the tone from the top. As I said, privacy has to be in the DNA of the organization. And that is only possible if there's a tone from the top, from the senior leadership. And third, most importantly, I think would be the budget. I think allocation of appropriate budget, considering especially privacy compliance is now at the forefront. It's been discussed at the board level, and they're trying to create a separate independent function. I think budget would, of course, be one of my wishes. And having said that, luckily, I think I'm in an organization where all my 3 wishes are already granted. But those would have been my 3 wishes from the board as a DPO for sure.
Yeah, I was about to tell what Bharat told in the last. All 3 wishes have been granted to me as well. But yeah, absolutely very, very valid point. The 4th one I would like to add is invest in technology. Right, many organizations still believe in Excels, right, spreadsheets, and do a lot of privacy compliances in spreadsheets. I think Vasudha brought out compliance, preference management center, cookie compliance. It's actually it's an ocean, cookie compliance. Right, many of us think cookie compliance is just go to the website, identify the cookies, and then you don't know when those new cookies will get dropped. You don't know what change will bring in new cookies, and if it's not there in your cookie policy, you're actually not abiding with the law, right? So I think investing in technology is one thing that really I would love the board to give a free hand onto. And like Bharat said, the top 3 things very, very clearly articulated. So technology is something that we have to adopt for a good privacy ecosystem to coexist. And to answer the first question, what is it that I would wish from from the regulator? One is awareness. I think that they have to work significantly on to bring awareness to Indian citizens or Indian data principles and the entire ecosystem, right? Without which we will not be able to implement this effectively. Okay, that's one thing. Second thing is please remove scraping, right, from the law. Okay, and then the third thing is I think it is very important for the board to come up with guidelines, right? Europe does that, Singapore does that. Just switching gears a little bit, AI, and that's the next big thing, right? And AI and Gen AI, that's being talked about everywhere. The European authorities have gone with a regulatory approach, whereas the Singapore and Canadian authorities have gone with a more guided approach, right? So they depends on how you look at things. So if I'm asked to ask our DPA, right, or DPB, sorry, I would go with remove scraping. Please come up with guidelines, and definitely awareness is significantly needed for a market like India, because privacy itself, unless and until you're exposed to the external market, that in other words, outside Indian market, you do not know what data privacy is. You look at ourselves. I mean, even we being privacy professionals, we give our phone number to enter an apartment, right? I mean, because the guy says the app will not work, I can't let you in. You don't have a choice. So I give my wife's phone number, but not mine, because she gets all the marketing calls. So it starts there, I think. Another huge challenge with DPDPA, if I have to ask, is please bring in processor obligations. Because if the processor does not have regulatory obligations, they will take things light, and unfortunately the fiduciaries have to start leaving aside the smaller processors who are actually putting a lot of effort in coming up, because they will not, okay, they may sign a contract, but will they be able to abide to the regulatory norms? Because you as a data fiduciary is going to be completely held accountable for data breaches, adhering to the law, everything, right? So that's my take on that.
Vasudha, the last word to you.
Yes, I think Jagan sir took both my wishes, so I will pile on that. But I think the first wish that I would definitely have here is some guidance from the regulator, right? And as he correctly pointed out, if we take just the example of Europe for this context, right? I think if we take the UK authority, ICO, they have templates from how to do a record of processing activity to a DPIA to even check the maturity of your compliance, right? So that is the granularity that they bring in for the organizations there. And if we don't have that in India, right, what will happen here is a huge startup ecosystem which is not being supported. Not everybody has the budget for an experienced DPO, right? On day one, what do those people go to? They don't have nothing. They don't have anything. They have these just 20 pages right now, and we all have those 20 pages, right? But we all don't know what to do with those pages, because I think there are a lot of things that are missing, and I think that's been the unanimous discussion here, that there needs to be guidelines, there needs to be specificity brought out in the guidelines as to what is exactly to be done. Right, I want to draw up an implementation plan for my company, but I am not able to, because I do not know what to go back and tell my business today, whether I need to reply to a DSR in 30 days, 50 days, what timeline do I put, right? So that kind of guidance, that kind of specificity is very useful, because, and then building upon the second point that Jagan sir mentioned, right, when you do not have any processor obligations, what you have only is a contractual obligation, and you are then flowing your compliance only through those contracts and creating a loophole for people to not comply with this act, right? When you want people who have data within their hands to comply, you have to bring in that. And without the lack of, with the ambiguity and these loopholes, this act makes it very difficult to be complied with right now as on date. So I think if I have these two wishes, I would definitely agree with these two here, and these are my reasons. Yeah.
I may add one point.
Please.
Right. I think what is really needed in India is data fiduciaries should help the small data processors to align with the law. Right. I think that should be a significant change in the way we approach things. Instead of just a contract, we should kind of guide them, because it's too much to ask the government for guidance and for data processors as such, because we have a lot of small data processors, right? So it will be really helpful if fiduciaries actually come together and build frameworks that data processors can adhere to and benefit from that, as well as elevate the privacy posture of those organizations.
Thank you. All right. So I think there was talk of a preference center that might be baked into the applications. I understand that consent life cycle is important, and we need to stop thinking about only checkboxes and notices. Two parts to my question. In the app, so where does the preference center in your heads sit with the consent managers? Because that's the data principal side of things. In the absence of interoperability, how would me as an individual be able to look at consents across different fiduciaries? So that's part one of my question. And part two is, if there are no obligations on processors, even with the absence of obligations, the processors are in turn interacting with multiple fiduciaries. So each fiduciary might ask the processor to now potentially integrate an API. And that if I'm a processor and I deal with 15 fiduciaries, my life is still hell, even though I don't have accountability in terms of the law. So just your thoughts on these two aspects.
Yeah, so I would draw an analogy with the account aggregator ecosystem here. So account aggregator ecosystem, to answer your second question, I think where there is one data processor dealing with different data fiduciaries, right? So account aggregator system actually enables such sort of consent seeking and consent management as well. So something similar to that is something we are looking at from a consent manager standpoint. Coming back to your first question, how about managing the consent management preference center? Should that be in the app or should that be with the consent manager, and how would it be interoperable? Depending on how the ecosystem for the consent manager would be built up, I would say that at the moment to start off with, and if you look at PhonePe as an app, currently we have consent preferences. So we have got a preference center in the PhonePe application itself, where it allows you to provide certain permissions and withdraw certain permissions. So at the moment, unless and until the ecosystem builds up, I think I would say that it has to be built within the app. And once the consent manager ecosystem does come up, I think we can either look at transferring this entire consent piece to the consent managers, or having an interoperable API with the app and the consent manager, where you as a data principal can go to the consent manager, log into it, and then have an interoperable consent manager preference center on the consent manager app itself.
Right. I think so. What I hear is interoperability is fundamental for this to work at scale. Even with the account aggregator, as per my understanding, if I have an account with one account aggregator, I will not be able to see my consents, or the other account aggregator does not have access to it yet. So while there is interoperability, it does seem broken. We'll have to see how things evolve.
But just to add to them, thank you for those questions, because consent manager is something I've been wondering about. What do you think are you open to the idea of mandatory integrations with consent managers? What you're talking about right now is an optional situation, but what if there are, as we are seeing the account aggregator framework roll out, and I know payments might be a different game from every other app out there because payments is already highly regulated, but what if all consent had to be with a single consent manager mandated by the government, some one ring to rule them all, and in darkness bind them. Sorry, not forget the last part.
Is it really needed? I mean, I don't think there is a need, because the simple reason is large organizations have their own consent management platforms.
No, but so let's forget the need part. Is there something that if it were to be mandated, is there something that you would, are there concerns that you might have about it become mandatory?
It depends on what is the level of integration that needs to happen. And that would be my first question, right? If it's just an API that says, transmitting consent versus revoking consent, I'm absolutely fine, because at the end of the day, you need to abide with the withdrawal of consent, right? But if it goes beyond that, yes, I would be a little more worried. Depends on how much information I have to pass back to the consent manager. How is that information going to be used elsewhere, right? By them or passed to some other fiduciary. So those are the aspects I would look into. But at this point in time, if it's just a basic consent versus withdrawal of consent API, I think we should be fine with that. Shouldn't be a problem.
Yeah, and I think also I'm aligned with Jagan on the payment side as well, Nikhil. As long as it is just a logging of whether consent was provided and whether consent was withdrawn, I'm fine, as long as there is no data sharing happening. Even if you look at PhonePe is an account aggregator. And in this ecosystem, there is total data blindness. So neither do we as an account aggregator get to see data, and that is how the entire ecosystem is built. So as long as I think we are not made to pass on data which is visible to the consent managers, I think it should not be a question to be debated.
And that's one thing that we are eagerly waiting for the rules to define some workflow and structure.
Okay. Vasu has a point?
No, Nikhil, I think really just my thought here is, I think we'll just combine consent and give one entity so much power to, manage consent. What is the role of a fiduciary then? Then the consent, why is a fiduciary responsible for consent? That's my just of the bat thought here. Right? If I have to manage consent through a consent manager, then consent shouldn't be my obligation, right? Then it should be the obligation of that consent manager, and that entity should be the one managing consent. If what you're saying happens, and I think if just building on what Dr. Saraf said here, that if it's just a yes or no, it's fine. But another aspect is that when you are dealing with regulators, auditors, right, you are supposed to show consent artifact, consent evidence that you have taken when it's recorded. How do you manage the flow of that from the consent manager when the obligation on me as a fiduciary is there to take consent? So will the consent manager pass on the data back to me and say, okay, this consent has been taken, it was taken at this time, and then there have to be obligations around tamper proofing and multiple other things, right, which need to be looked at here. When we are talking about one entity handling consent, and I think it's a bad idea. I mean, one person or one entity, there's a breach, you are gone, right? So I think the fact that each entity is handling its own consent, and there's a reason that fiduciaries have these obligations, I think the sanctity of it should stay for the time being. That's my thought here.
So just to let you know, this is an idea that does exist. But Akshit had a question there, then I'll come.
Yeah. So hi, my name is Akshit. My question is that, say if I sign up for a website which says that my data will not be shared with anyone else. Now, how will I know that the company is actually following what it is saying? In that context, do you see a need for an auditor in the whole privacy perspective, or do you see a need for, if there is a way for the citizens or the principal to check if that data is not being shared with third party? And second question is that what's stopping a disgruntled employee in a company from downloading data of millions of people in an Excel sheet and sharing it with someone else? If there's any confusion, I can repeat.
No confusion. We were just trying to figure out who's going to answer it. So your first question is, can you repeat your first question? I was more focused on your second question because of data breach, right?
So if a company says that they will not share my data with anyone else,
got it. I remember.
how will I check?
No, I remember the question. I just lost that thread. Well, first and foremost, your notice should call that out very clearly, all right, on how your data is being shared. Okay. So is there a way to find out if your data is shared and with whom? I don't think so in this particular in DPDPA. You have the right to access, right? So primarily, and also the other caveat in DPDPA is it's a summary of your data, right? Summary is not defined. So whereas regulations like GDPR, CCP and all that, they clearly call out every data about you, your emails. If let's say, for example, if Bharat and me are working in the same company and we speak about you, who is working in the same company, that becomes your personal data. I mean, if we say Akshit has performed great in the last 1 year, but his performance actually dipped in the last 6 months, that becomes your personal data because we're talking about you. So it goes to that extent. But here, summary of data. So yes, the law provides you a provision, but it's not detailed enough to understand. I'm hoping that you can ask where my data is shared. But at the same time, the law also allows, or not allows, but holds the fiduciary responsible to be able to share the data only if there's a lawful base, only if there's a purpose for sharing, not just for the sake of sharing, right? So to take that point to the next step, when you called out audits, yes, that's definitely one of the criteria that is already given for significant data fiduciaries. But for fiduciaries, yes, that's a good option to audit themselves and to get audited from external parties. All right, from external parties is when you actually find out these nuances. Otherwise, internal audits only give you an exposure to certain aspects. Now, coming to the second part, I think it's a very excellent point that you brought out. Okay, some disgruntled employee can do this this activity, and it has happened across so many companies in such activities. Which is where I like this DPDPA also calling out duties of principals, right? Duties of principals actually calls out obligations on principals, right? Now, the reason why I brought out duties is there could be a disgruntled employee who can raise a data subject request or a data principal request in a completely haphazard manner, right? So it becomes the responsibility of the data principal to ensure that it is being lawfully done for the right purpose. Okay, that's one thing. Now, coming back to your point on disgruntled employee leaking data, yes, the data fiduciary will be held accountable for this particular action, right? But then the law also has when there are certain points that are called out on how they will slap penalties, right? So if you have taken the right measures to protect such data, if you have taken, for example, implement certain measures like an effective DLP policy, right? A data leak prevention policy, which does not allow you to send emails with attachments to external websites or external email IDs without notifying, right? So it has to be approved. So if there is a DLP installed, right, that will automatically block it, right? Awareness, bringing in awareness. Third is use technology in terms of when you want to transfer data outside. I mean, these are the aspects that you can take as an organization to avoid the point of view that you're bringing in. Okay, if you have to, let's say, for example, my finance team is transferring data to process my payroll to a third-party vendor. Okay, that person can misuse that instance. If I am sending it over email, copy some other email ID, right, and it goes out. So instead, I bring in a technical intervention saying you can only upload this data to process payroll onto an SFTP protocol or HTTPS protocol, right? So then the data is secure and you are putting it in the right place. okay, rather than allowing such misuse. Okay. So it is up to the fiduciary what kind of controls they need to bring in. Like I spoke to you about DLP. DLP also can be configured to just say, warn people or warn your manager that something has gone out versus block something going out. Okay. You can bring in certain firewall restrictions not to access, not to send out any attachment to your personal email IDs, right? Or only upon a permission. For example, your payslip you may want to send to a personal email ID. That based on an approval you can send. So bringing in technical measures will avoid such scenarios. Okay. But if something happens like that without the technical measures, the data fiduciary will be held accountable, and they have to answer what kind of procedures they have put together and take the respective action. And of course, face the penalties if there are any penalties. You want to add something, Varun?
No, I guess it is, especially on the second question, I agree that it is the data fiduciary's accountability and responsibility to implement. Even if you look at the IT Act 2000, right, or the SPDI rules, it had a very specific requirement that the organization must implement technical measures, technical and organizational measures to ensure that the data is protected. So what are those technical and organizational measures has been exactly enumerated just by Jagan. So unless and until you have put in those, and if there's a breach that happens in your organization through a disgruntled employee or through a third party that you have shared it with, I think unless and until those are there, I think the penalties are going to be heavier. And of course, the auditors are going to look at you in bad light because you did not implement the controls that you were responsible for.
Any additional questions?
So one of the new things under the DPDP is the purpose limitation, which is sort of an automatic thing. The illustration says that just because you've given consent for telemedicine app access, that doesn't mean that the app can take your call logs. Given that even as how it's written, it's a little vague as to when and who does this assessment. How do you communicate this to your organization? Is it just a matter of having enough on book to say that this is also necessary? Or is it an actual clinical exercise of that, okay, this data element is for this, given the fact that, for a large part, we have never been sure about what we're going to do with this data. A large part of always be that, once we have enough, maybe we'll find out something. So that's my first. Second, you spoke a lot about the opt-out mechanism, right? That when you're using a data scraper, there should be a provision that lets you say that, I don't want to use anything that you are not sure of is compliant. What would be your recommendation if you were actually the DPO of such a scraping website? Like, for example, a contacts aggregator. Is the recommendation just going to be that, guys, sorry, funds over, SPDI is done with, send out notices to everyone you have on the database that, listen, we received your contact and that you are okay with us continuing to maintain this repository? Or is there some other workaround to, aggregation and consolidation? And final, how much do you think anonymization is going to become the internal process game, given the DPDP Act?
Sure. You want to take the second one, the data scraping one? I'll take the first one. Okay. Sorry, could we just come back to the first one? If you could just repeat in short.
The purpose limitation.
The purpose limitation, yes. So the purpose limitation will be basis the governance framework that an organization will define internally. So what does that mean is, say, for example, we are a payments app and we are processing payments of our consumers who are landing onto our application and creating accounts, etc. Right? So we will, as an organization, will have to define what are the purposes for which we will require the different data elements for processing of payments. If there are additional purposes or additional data elements for which there are separate purposes, we will have to carve that out separately with, as Jagan rightly mentioned, in the privacy notice with granular consent. Now, there are many number of implications why granular consent becomes important, because there is an opt-out associated with it and you want to utilize maximum amount of data. So, coming back to the purpose limitation, it will be your internal policies and your privacy governance framework, which will actually define this particular use case. Coming back to specific use cases. Now, this is where privacy by design comes into play. say for example, a product is being developed where it is about making payments to say third parties, and there is certain amount of data that has to be collected. So you have to sit with the product manager, try and understand the different use cases for which this data will be utilized. Are those use cases valid or not is something that the privacy function can actually determine, and actually lay down the particular principles basis which there can be certain purposes. Now, these purposes can be from a legal standpoint. There can be other considerations like ethical and moral considerations as well, right? So principally, as an organization, do you want to collect certain amount of data for a particular purpose, and does it fit within your ethical and moral considerations as an organization? So those are the sort of determinations that the governance framework will have to put in place, and the privacy function as the custodian of data will have to determine this and make an analogy and actually come to a conclusion whether the purpose limitation that has been defined, the data elements that have been collected as part of that purpose limitation, whether that can be collected or not. So that is how this entire framework, along with the privacy by design, will determine the purpose limitation.
Just my 2 cents here on
Sure.
the purpose limitation part. I think what's important really here is to when we are looking at a new law, right, in India, is to also understand with the teams, as was earlier mentioned in this session itself, right, to have a training specific for those functions, right? For example, you have a product team which is designing a new product, and they think आज डेटा ले लेते हैं, कल सोचेंगे क्या करना है, right? That attitude, that change that has to come, right, in the business, that's something really important. That mentality shift that has to come is extremely important, given where we are today, right? And purpose limitation, as Dr. Saraf completely rightly mentioned, that it will come to privacy by design, where this is where those principles come in, whether they are mentioned in the law or not, right? Operationally, they do have a hold over how products are designed, but that ethical shift, a mentality shift that has to come in the organization, that's where training, speaking, and stakeholder engagement comes in very handy to handle such kind of situations, so that they are not at a stage where the product is designed, you're at Q&A, you've done everything, and then you're deciding, oh, now I do not know what I need this data for and which purpose, right? So that's my just thought here on this one.
If I may add to purpose limitation, absolutely awareness is key, and what Bharat mentioned was very apt. I would say the culture of the organization actually makes a huge difference, and you as a DPO and the privacy function should also keep a watch on what's happening in the organization, right? There are 3 ways of doing it. One is your impact assessments, right? When there's something that is mentioned in your impact assessment, you need to ensure that is what is being followed. 2 is your data inventory and the data lifecycle. Okay, when you have to keep looking out for instances where something is not being followed. I mean, that's how compliance runs, right? And that's the best way of looking at it, rather than looking at is this being followed. You need to watch out for that as a privacy function. So if you bring in that culture, automatically purpose limitation will be adhered to, right? And like Vasudha was saying, it's very important to socialize and make people aware that what they should be doing and what they should not be doing, and the exchange of data flow between the organization functions as well.
Do we have time for more questions?
With 20 minutes over time, but this has been a fantastic discussion. Dr. Saraf, Jagant, Vasudha, thank you so much for this. Thanks, Rahul, for great moderation. And thank you everyone for joining us for today. There is tea available. Tomorrow, we'll be starting with a discussion on user rights. We have 2 privacy commissioners from Iceland and from Japan joining us for a discussion. We're going to look at obligations of data fiduciaries, and then there are a couple of other sessions. So we have a full day planned tomorrow. I hope to see you tomorrow.
I just want to add one thing. Lawyers, please learn technology. It's for your good. I mean, you will really be able to make a huge difference I'm not saying learn technology as learn coding and learn the nuances of technology. Like for example, Gen AI. What are the implications of data privacy in Gen AI? Right? Discrimination, bias, impersonating. All these things are something that you need to.
I actually look at three skill sets: lawyers, law, technology, and business. All three need to work together. Because the business aspect is something which sometimes the lawyers don't get, and quite often technologists don't get.
No, absolutely, very, very valid. If you are in that space, you're completely elevated. I mean, you're playing at a different ground altogether. So with that, I would say thank you.
Thank you. Thank you, everyone. There is tea, and please feel to mirror around. We have a little bit of this room for a little bit longer. Thank you.
Very